at the heart of all what we do. Ladies and gentlemen, good morning again. It is with great pleasure to welcome you. Let me start with that. I know you will be welcomed. Today, we are honored to be joined by Professor Broderick from the UNESCO Chair on Human Rights and Peace, Maastricht University, Netherlands, who is representing the University of Maastricht. Professor Broderick, we acknowledge with great respect. This reflects the spirit of collaboration and mutual commitment that this MOU represents, and we look forward to the journey of working together in pursuit of our shared goals, which the university aspires. This is not the first time. Let me give everyone a brief background. Our institutions have worked before even the first MOU that we have in 2015. The UNESCO Oliver Tambo Chair of Human Rights interacted directly with the UNESCO Chair on Human Rights and Peace within their global framework of UNESCO chairs. And Professor Nasila Rembe from University of Fort Hare, a retired professor, and Professor Fons Komans from Maastricht University, who was the coordinator also of the Center of Human Rights of Maastricht. Both of them worked together even before, as I've mentioned, the 2015. There was a relationship. Why I'm saying so is because I was here 2007 and 2008. I have experienced working together with them. I received a scholarship to go and visit the Maastricht Center of Human Rights. The scholarship was from UNESCO. That was 2007, 2008, before 2015. With this scholarship, I managed to visit many institutions. That's when I was still doing my doctorate. Studied, went to ILO Institute in Geneva through the scholarship. Max Planck in Germany through the scholarship, and other institutions. I could visit all places of research within the Europe through the scholarship. It didn't end there. 2015, March of 2015, Professor Komans decided to seal this relationship, and Professor Rembe. They discussed around having an MOU. As a result, Prof. Komans came down here to the University of Fort Hare from the 15th to the 19th of March 2015. During this time, Prof. Komans could share with us the rich experiences of Maastricht universities. In that university, they had a problem-based learning, we call that PPL, which excited us, some of me and my colleagues, that, hey, this is a good thing that we would like to pursue. Explained with us within that week, make presentation to our students, and following that, an MOU was signed later in the year of 2015. Maastricht signed that one on the 19th of October 2015. together with the University of Fort Hare. To cement this relationship, then the Dean of the Faculty of Health Sciences, because of the PPL that was one of those activities related to students and academics that were there in our MOU, tried to go there and see what the university is offering. 6 colleagues from the law faculty and the health department visited Maastricht, the university, to tap from the experiences and what the university offers and what, as a University of Fort Hare, we can learn. It was an exciting journey. I've learned there, the PPL, how they were doing it. The classes, attending their classes, going and attending everything that the Faculty of Law at the University of Maastricht were doing. Activities, research, and their students' engagement. Coming back, reporting to the faculty, everyone was excited. I don't know whether Advocate Seth is still intending to go there, because we were more than willing to go and look, because it was exciting. PPL was exciting. We know that nursing science, they are doing that. We can still learn from them if we need to, because they are still doing that. Again, in 2018, we had a conference, a joint conference, together with the Maastricht University. That conference that we hosted under the theme Transformative Constitutionalism, it cemented our ties. And it is worth mentioning that this conference was a major highlight of the year 2018. This signing of this MOU today is a continuation. It's a continuing journey of partnership that we have and collaboration. But now we are strengthening and formalizing again through this MOU. We are continuing to partner on those areas that were covered and now are covered under our own MOU that include education, student exchange, research, academics, student programs. So all these are covered even under this MOU. I don't want to labor on areas that will be covered by other colleagues within the House. Now, again, let me welcome you again in this important event. Thank you so much.
All right, thank you so much, Dr. Albisi. A lot of history there, and of course, it's good. It's giving context to this MOU or signing of MOU. I can almost agree with what you said, and I know as a faculty we had a lot of interest on the PPL. It's something that I think maybe it will be the highlight of this new MOU. Getting back to our program, we're supposed to be having international office, Mr. Molife, and I'm told that because he's not here, and there will be some slight changes, which is going to work in our favor in terms of catching up with time. Now, which will take us directly to Professor Broderick for some remarks relating to this MOU, more in particular from the side of Maastricht University. Let me, without wasting any time, Prof, over to you for your comments. Thank you so much.
Thank you so much, and I hope you can hear me clearly. Dear Deputy Vice Chancellor, dear Honorary Judge, dear distinguished faculty members, and dear distinguished guests, good morning. I would like to start by saying to all of you, happy South African Heritage Day, a monumental day on which you celebrate the wealth of culture in your country and the many populations that make up your great land. It's a great pleasure to be with you online to mark this day. I'm sorry that I cannot be there in person, but I have just returned from the Global Campus of Human Rights, where I was discussing PBL, problem-based learning, with over 100 universities from around the globe. So I'm very much looking forward to discussing PBL with you under the context of this memorandum. So thank you for inviting me to join your colloquium, and a very special thank you to Professor Natlama for making space in the program to sign this important memorandum of association between your university and my university, Maastricht University. By way of introduction, I have been in your beautiful land of South Africa twice in recent years, so I'm very sorry not to be there now. I actually lived in Africa as a child for a short time with my family, and I have taken over the UNESCO Chair on Human Rights and Peace from Professor Fons Koemans, who was already mentioned. He is a dear friend of mine, and I now direct the Maastricht Center for Human Rights. So it's both an honor and a privilege to be here to launch this memorandum of understanding, and I look forward to taking our collaboration to new levels. I really feel this moment is more than a ceremonial formality. It's a milestone because it represents my taking over this collaboration and a shared commitment of our universities to advance knowledge, foster collaboration, and build bridges between our continents, because we have so much to learn from you. You already mentioned what you learned from us during visits here, but we have so much to learn from your diverse land, from your diverse universities. The memorandum is built explicitly on principles of mutual equality and benefits for both universities. So I really want to ensure that these principles underpin everything we do: equality and benefits for both of our universities. The University of Fort Hare is steeped in such a legacy of intellectual leadership and transformation. It's one of the cornerstones of higher education in South Africa and has nurtured generations of leaders that have shaped your nation and also the continent. And as you already mentioned, Maastricht University, on the other hand, is renowned for its problem-based learning, an innovative teaching methodology that I have implemented now for 13 years. We also have a great international outlook. Maastricht University is considered an academic leader in Europe and beyond, and we try to engage globally. As I said, we have much to learn from other diverse nations. We have so much to learn, so I look forward to that. The memorandum has been a long time in discussion between myself and Professor Natlama. However, I don't feel that today is an end point, it's just the beginning. It opens doors for joint research, conferences, educational exchanges between our staff and perhaps also our students, collaborative innovation in many ways, and capacity building, including in my own areas of research and teaching for UNESCO. So personally, I research on human rights education, socioeconomic rights, equality law, and disability law. So I really hope that these areas can match with some of the areas that you are interested in your university. I already said that this paves the way for our students and staff to engage in diverse perspectives and ways of doing things, and also to prepare for the global challenges that lie ahead, the global challenges that are here: climate change, sustainable development, and global health concerns. These challenges affect the global north and the global south in different measures. Often they affect the global south more, and I really need to engage with you to understand how we in the global north can move forward our research and thinking to address these challenges. So I can think of many ways in which I want to collaborate with your university. So as we formalize our partnership today, I want to say, let's commit to nurturing that partnership with energy and vision. Let's translate the words in this memorandum into action and opportunities and inspire future generations. As you perhaps saw, Maastricht University has recently adopted the Maastricht Principles on the Rights of Future Generations. So we're very much a forward-looking university. We've done the hard work now in drafting the memorandum, and as Professor Ntlama herself said, the ship now has to sail. I wish to extend my heartfelt thanks to all of those who make this collaboration possible. I hope it will be a fruitful journey which strengthens ties between South Africa and the Netherlands, between Africa and Europe, and I look forward to welcoming some of you or all of you here to Maastricht University. And I would love to visit your beautiful land again and learn more at your esteemed university. Thank you very much for your attention.
Thank you so much, Professor Broderick, for those important comments. Indeed, it's not just an MOU, it's a milestone. I fully agree. Without wasting any time, then we'll take, maybe before that, another round of applause for those important comments. And then proceeding still under item number 3, which is comments, we take comments from the side of the University of Fort Hare, Professor Nomthandazon Tlamamakanya. A round of applause.
Morning, colleagues. Let me take this opportunity and also extend the greetings. Do I want to say the protocol is observed because it has been extended already? Or should I start with the management of the university, our institutions of traditional leadership, the colleagues, particularly our guest who's online, Professor Broderick, and the University of Maastricht at large? Let me just say, the entire community that is here. Mine is also briefly to say, here we are. As we have been discussing, the moving forward, that parable of the ship which has long sailed has already been given the background by Dr. Lubisi Bizan. But now we are here, and we have been discussing this matter forward, that today, this is no longer about us questioning as to who we are, but it's about putting flesh on our being. And when we put flesh on our being, we were skin-boned, but this relationship now has brought in meat in that skin-boned body. And that skin-boned body, then it means the internationalization of the relationship between the University of Fort Hare and also Maastricht. And this fits well because we are here advancing the principles of customary law, and we have Maastricht that focuses generally on human rights. So we have that concept now of localizing international prescripts into our own domestic sphere, and also the international prescripts, our domestic sphere, into the international sphere. So there is this now, a global identity between these two institutions, of which Professor Broderick has spoken about. So in moving forward, this relationship is going to establish or develop or continue on the relationship, on how we are moving forward, on how we do exchanges, on how we influence each other in terms of our curriculum development, on how we interact as a staff and students, so that we continue to transform the way in which our own laws, can be what? Can be lessons on the way in which we do things, or how the international prescripts as well can be an influence on our own being. So with that being said, colleagues, I'm not going to say much. Professor Broderick, the day has come. We are no longer now going to say, hey, there's a time of jittering when the legs or the knees don't want to carry us any longer. Because as you see, these are the colleagues now that are here to witness this moment. They are going to come back to us tomorrow and ask, where are you? What progress have you made? So tomorrow, we are going to come back and give a feedback that these are the strides that we have taken in ensuring that our relationship is strengthened. And the university is also here. They'll ask us, what happens between the two of you? Because we have to give an international standing to the university. We have to give an international standing to our communities. We have to give an international standing on how our judiciary as well enables this international framework in our domestic spheres. So with that being said, thank you, colleagues. Professor, thank you very much. We are pleased to have you. Thank you.
Thank you so much, ladies and gentlemen. Thank you so much for those comments, Professor Ntlama, localizing the international cooperation between these two institutions. Signing MOUs is something that is normally that difficult. What is always difficult is to make sure that we implement it. I'm sure it's one of those areas that we need to focus more on, in other words, ensuring that we implement the arrangement between these two institutions. I thought I would see Prof. Pogo. Unfortunately, I can't see him. Professor Pogo is the current chair of our UNESCO OR Tambo, chair of human rights, who is, as Dr. Lobisi indicated, it's part of the initiation of this arrangement between the UNESCO chair at Maastricht as well as a UNESCO chair here, which in the past it was occupied by Professor Rembe. Unfortunately, I thought I would be able to see him and then maybe ask his one or two comments from his side. Oh yeah, I thought you'll stand up, Prof, just for everyone to see you. Oh, is over there. Professor Broderick, I'm sure in a very short space of time you will also be in communication or contact with him as well. Moving right along, our program now, we get to item number 4. Item number 4, it's a declaration of the signage of the MOU, which will be done by the acting Vice Chancellor, Teaching and Learning, Professor Osote. I was looking for him, hoping that I'll see. Oh, right in front of me. Okay, Prof. Osote, over to you.
Just to begin with a correction, Program Director, Acting Deputy Vice Chancellor must not be seen to be usurping traditional leaders here present, judges, any magistrates in the House, Professor Andrea Broderick from Maastricht, Dean of Law, Professor Kisi Njatini, professors in the House, academic colleagues, distinguished guests, students, good morning. Molueni. I'm naturally pleased to have been asked to play some part at this occasion, the signing of the MOU between our university and the internationally renowned and esteemed Maastricht University. I must say that I struggled with with the item assigned to me. Wasn't quite sure exactly what it entailed. Declaration of the signage, but I've tried to make something of it. So I'll share a few remarks, and then thereafter I'll zero in on that item. I think definitely that the MOU and its signing first is significant at the level of the symbolic. Clearly, symbolically, the signing of the MOU marks a significant milestone in the history of the university. We should be proud to be collaborating with an EU-based university that has the global reputation and gravitas which Maastricht University has. Prof. Broderick, I've been on your website in the recent past looking for doctoral examiners for thesis, because at our university we have to have two international examiners for every doctoral thesis. So I do have a good sense of how, of the kind of work that yourself and your colleagues do academically. Colleagues, on a substantive note, the significance of the signing of this MOU with Maastricht University lies in the fact that it enables us to commence what I hope will be an extraordinary journey of collaboration, innovation, and mutual growth. Still, on a substantive note, the partnership founded on the MOU represents a convergence of our shared values and goals. By pooling resources, expertise, and passion for knowledge, we can achieve far more together than we could alone. Colleagues, let's remember the African proverb that says, if you want to go fast, go alone. But if you want to go far, go together. In closing, allow me to say that this MOU is also special because it enables our two institutions to contribute, hopefully significantly, towards bridging the North-South divide. I believe Prof. Broderick mentioned that in her remarks. In trying to bridge the North-South divide, this partnership between our two institutions also embodies the spirit of global citizenship and our shared commitment to addressing the world's most pressing challenges. On behalf of the senior management of the University of Forte, I would like to express our deepest gratitude to Maastricht University for their willingness to collaborate, and to the teams from both universities, Prof. Ntlama, Prof. Broderick, the colleagues who assisted, for your efforts in making this partnership a reality. Okay, I'm told that I should sign it. Okay, colleagues, let me do that before I close. It's not like trying to. Colleagues, I'm told that the seating arrangement for the signing is a different one. Yeah. Colleagues, let me close with the following words. I declare the Memorandum of Understanding between the University of Fort Hare and Maastricht University signed, sealed, and delivered. Let the collaboration begin. Thank you very much.
from the side of the University of Fort Hare, Prof. Osode is going to sign, but if maybe for a photo can ask Prof. Njotini, the Dean, Prof. Ntlama, and maybe with other colleagues who might be interested to take a photo for the purposes of unfortunately, or in fact, I'm informed that from your side, Prof. Broderick, you already signed. All right, a round of applause for them while they are taking the picture. Another round of applause. Prof. Broderick, we're sure that soon we'll see you so that you can complete that picture. Thank you so much, Prof. Osode. Or you indicated that we didn't give you a clear picture of what to do. When you are given a blank check, clearly you know how to complete it because you did that work very well. Thank you so much, ladies and gentlemen. That takes us to item number 5, which will complete this part of the session. A vote of thanks by Dr. Ndlovu.
I thought you'd clap as I walk here. Molweni and good morning. Mine is a simple and a difficult task. I stand on all protocols, but allow me to say that to our highly esteemed traditional leaders, whom we respect and love so much, to our judges, to my colleagues and to our distinguished guests from all over the country and the continent and the world. I think we've got a colleague from Hong Kong. Allow me to greet you this morning. My name is Ntandogai Ndlovu. I'm the HOD Public and Constitutional Law, where this MOU belongs. That I must claim. I think a lot has been said, but allow me to say a few words in relation to this MOU. I was involved at some time, and my line manager here at some time was putting a whip that I want to see this happening. Then I'll be rushing to Prof. Ntlama and say, Prof, this MOU must see the light of the day. And Dr. Lubisi did give us sort of a history into that. But it is my singular honor to deliver this vote of thanks on this historic occasion, on the renewal agenda that we have in the faculty and the university. Which marks really the memorandum between us, the Faculty of Law and the university at large, but the Department of Public Law and the UNESCO chair in our university. As our program director did say that we also have and host a UNESCO chair, which is going to work closely with the UNESCO chair at Maastricht University in the Netherlands. So the MOU is more than just a document, and I think our TVC did say that. It is a testament to our shared vision of advancing human rights at a time when the world is facing global crisis. I think this MOU is going to allow us through teaching and learning, through research and innovation, and through community engagement to engage in serious discussions that are going to solve local challenges here in Alice. Challenges in East London, challenges in the province, in the country, the continent, and beyond. So it is not just a document like it was said earlier, but it will allow discussions to take place, intellectual stimulating discussions that might offer solutions to some of the world crises that we're currently facing. And yesterday, if we did listen to the president at the UN, he did speak quite massively in terms of some of the challenges. And we hope that MOU will feed into those discussions that were being shared by the head of state. Because to us, it does sort of, it is not only confined to us alone, but does resonate across the country and the continent, and indeed the world over. And therefore, our collaboration carries immense significance. And I've already said that we're going to do this through problem-based learning that was spoken about and experiential learning, to better approaches in terms of equipping our students and the complexities that we face and the world challenge that we see. We also reaffirm our dedication to research and innovation through this MOU, with exciting opportunities for both our student and staff exchanges, which we're going to see, I think, quite massively. But allow me to say that this also allows important dialogue between the Global South and the Global North. I think for the longest time, we've been learning things from the Global North. But this MOU allows, as we undertake this discussion today, through the knowledge, what can we tap into our systems and customs that can inform our legal system, to allow our colleagues from EU to learn from us as much as we learn from them. And I think this is the biggest part of it, because we are going to share exchanges. So it's not going to be a one-way road where we learn from them, but they're also going to learn from our knowledge systems, our indigenous knowledge systems, African customary law, and see how can we inform their systems as well. And allow me to express my gratitude. When I assumed the responsibility of heading the department, I took over from Ms. Mbolambi, my predecessor. She's sitting right here, who has done a lot of work in the background on this particular MOU. And thank you so much for holding my hand going through the processes when I was getting all the signatures and other stuff. Thank you so much. And I also want to thank Prof. Broderick, together with Professor Nhlama, for working the groundwork. Our Dean, Professor Njotini, for giving us the space really to work and the leadership that you provided during this process. The offices of the TVC, both academic, teaching and learning, and as well as research, they provided support in all systems. And indeed, the office of our Vice Chancellor. And I want to say that in all other university structures, including the CFO and others, and legal. And finally, I want to thank each and every one of us that is here present to witness this important milestone, to say your presence here is not just an afterthought, but it is a significance that you do not take us lightly, but that you support our teaching and learning, our research and innovation, and indeed that this MOU is not the end, but the beginning of the rich and the enduring collaboration, and I think that was said by Prof. Broderick. And on that note, thank you so much for all of you for listening to us and witnessing this part. Thank you so much.
Thank you so much. This session has ended. Prof. Nhlama will give us direction as to where we're going in terms of the conference. Thank you.
Okay, thank you very much, colleagues. Let me also say, Professor Broderick, you have already been thanked, and you are very fortunate as well to have this connection with our institution of traditional leadership. It is here. Maybe you are seeing one of them. Come, my prince from Namibia. I'm looking, yes, come, so that Professor Broderick sees you. Come. Professor Broderick, This is the diversity that we are talking about. This is what we want to share with you, so that when we develop these programs, we develop programs that are very diverse, that are very unique in our own being. So with that being said, thank you very much, Prof. Our session now has come to an end, and then we'll keep talking. Thank you very much.
Thank you to all. Thank you.
Thank you, Prof. Thank you very much, Prof. As I've said, our session has come to an end. Have a great day, and we wish that all the best for your university as well, and also for our own relationship. Thank you.
Thank you, and I will be in touch very soon. Thank you.
Colleagues, I have been ordered. When you receive an order, even if you are the dabao, because you do listen to your brother, because that's what keeps the family household glued. So the dabao does not have this final word, but the dabao works together with the brothers. She might stand up and say, "Not here, I'm Zinkabao." But that is me. Colleagues, let's just take a 5-minute break, and then we all come back here for the next session. Please. Thank you. Thank you, Prof. Colleagues, the coming back is at 5 to 11. Thank you.
into the business of the day. I am Alizwazi Sile from the Faculty of Law, and I have the pleasure of chairing our first session for today. The theme for our parallel session, rather, is recognizing customary law in diverse communities. And I'll call on our panel. As I call your name and introduce your topic, please make your way to the front. First up, we have Dr. Tebelo Matsela from Northwest University, and their topic is the consolidation and reform of African customary marriage law in South Africa, protecting women's rights under the RCMA without Western legal hegemony. Dr. Matsela, are you here? Okay. Let us move on to Mr. Vuisa Pikashe. His topic is legal pluralism and recognition of customary law in South Africa. Mr. Pikashe, you may make your way forward. Can we have a round of applause, colleagues? Thank you. Up next, we have Ms. Kiabetswe Masejo Mokoko. Ms. Mokoko, are you here? Okay. Ms. Maria Shanga Maseka from the University of Fort Hare, and their topic is gender and customary law. Lastly, we have Ms. Lindokuhle Kubeka from the University of Fort Hare. Their topic is the legal effects of public participation of customary communities on the right to development in South Africa. Ms. Kubeka, are you here? Okay, it seems we only have two presenters, and I'm very proud because these are students from the Faculty of Law, so let us lend them an ear, and after they present, we will then move on to the question and answer session. Mr. Pikashe, you may proceed. Can we get assistance with the projector, please?
Greetings to the House at large. I would like to first greet the Vice-Chancellor in his absentia, the staff from the University of Fort Hare, and the esteemed guests from various places and disciplines for where they're coming from. Allow me to reintroduce myself. My name is Vuisa Pikashe. I'm currently pursuing my studies of law, and I'm doing my second year. And I must say that I am still a novice researcher, and I'm very grateful to be having this opportunity to present this topic and being it embodied with the African customary law. So my topic today pertains to the legal pluralism and the recognition of African customary law in South Africa. So I would like to first reiterate to why did I chose this topic. So to me, the recognition of African customary law seeks to both the promise of restoration and the weighing of the contradictions that we have in our societies. It represents the heartfelt effort to honor and breathe the information of systems that were once stifled and dismissed. So I want to acknowledge the fact that we don't need to be dismissive about this issue of the recognition of African customary law. This forms the basis of who we are, and this forms the basis of how was the South Africa was founded. So to further substantiate is that, for me, the recognition of African customary law is the source of both hope and challenge. It embodies the commitment to restoring the dignity to system that has historically been marginalized, while simultaneously highlighting the constraints of the recognition since the conception of the people from the Dutch, Jan van Riebeeck, when he arrived in the Cape of Good Colony. So now I want to explain what does it mean to the topic of legal pluralism it actually refers to the legal systems that we have here in South Africa. So today I would like to address the topic of the legal pluralism and the recognition of African customary law in South Africa. Rather than merely describing the current situation, I am going to challenge our thinking around this issue. Are we genuinely recognizing customary law, or are we simply managing and controlling it within the framework of the Constitution? So I also want to refer to what my lecturer has always taught me in class, Professor Ntlama. She was teaching me the introduction to law. She always referred to why do we always have to question the identity of who we are? Because this is our nation, this is our land. So South Africa boasts the unique legal landscape with three interconnected systems: the common law, the statutory law, and African customary law. While they are intended to coexist together, but there are still questions that are raised to say that the customary law is being sidelined, the customary law is not recognized to its full context, and the customary law is not understood within its own background. That's why now we have the challenges of the judges not being able to interpret the African customary law with its background, and the convictions of that particular society refers to what is customary law. The Constitution, which claims the supremacy over all legal system, this contradiction is crucial. This contradiction is crucial for us to confront as to explore the dynamic of the legal pluralism. Now, I have prepared a sequence of these events that has happened from the pre-colonial era, the apartheid regime, and the post-constitutional dispensation, which claims to recognize the Constitution and further embodies the principle of transformative constitutionalism, which in my own context, I believe that it is just merely a symbolic, because it doesn't address the current issues that we face in as far as the customary recognition is concerned. African societies were largely self-regulating through the systems of customary law. Customary law was flexible, and oral community-based ruling changed depending on the needs of the group. Chiefs and traditional leaders held the authority, but decision-making often relied to the collective agreement of that particular community. Now I will further go to the colonial era to subordinate and distortion of the African customary law. When colonialists arrived, they refused to recognize the customary law as equal. The repugnancy clause meant contemporary practices could be recognized only if they were in line with the Constitution. Customary law was codified in a narrow and applied in a rigid way, stripping it of living and flexible nature. Chiefs were turned into state functionaries, enforcing colonial policies instead of serving the communities. Now, moving to the apartheid regime, the administration of African customary law. The apartheid regime intensified the control. Customary law was recognized only under black law in the act that was established in 1927, the Black Administrative Act. It was applied in separate courts, the Natives Commissions Court, where white officials interpreted it. Customary law became an instrument to control, to enforce the segregation and the patriarchal systems. Moving to the post-democratic dispensation that we have, which claims to recognize the customary law. The 1996 Constitution actually does give the recognition to the African customary law, but the question is, to what extent? Section 211 of the Constitution applies that courts must apply customary law when applicable and in line with the Constitution. Section 39 further states that it must develop in line with the constitutional values, equality, dignity, and human rights. Section 211 of the Constitution mandates that the courts may apply a narrow it to evolve and alignment with the constitutional values. Section 9 introduces the principle of equality. Therefore, while customary law recognized, it exists under the conditional terms. When customary law practices conflicts with the constitutional rights, it is in the latter, the Constitution prevails. That creates a hierarchy and undermines the notion of the true pluralism. And now I would like to refer to one of the most landmark cases which establishes what customary law is. Considering the case of Bear, where the court struck down the male primogeniture, although the decision was advantage to gender equality, it also imposed a judicial perspective on communities' practices. Similarly, in the case of Shulubane case, the court acknowledged the communities that can develop their own laws, but the validity of the development in the communities or the judicial system were only vested in courts. In MN versus MN, while the customary marriages received the recognition, they were still filtered through the constitutional standards. These cases illustrate the recognition theme that needs our urgent recognition to try and reinforce us understanding why do we need this legal system, because they were meant to coexist together, not to sideline the African customary law. Even the Constitution itself, as it embodies the principle of transformative constitutionalism, but it doesn't show to interpret the acknowledgement of African customary law. Now, before my conclusion, I would like to move to the recommendations that I would like to pose to the House at large. Corinne van der Wilsel stated that the legal consequences of customary law are still unclear, which has led to recommendation to regulate the customary law adoption. He further stated that the customary law adoption must first be contextualized before regulating the customary law adoption. The connection between the African customary law adoption must first be contextualized with the background understanding against the knowledge. In the case of Motsepe versus Khoza, the court recognized the customary law adoption and occurred with the new dawn of the new constitutional dispensation. In conclusion, while South Africa asserts that the commitment to legal pluralism, we must recognize that it often resembles the managed pluralism conditional, supervised, and reshaped to fit in the constitutional values. The pressing question remains, do we possess the courage to allow African customary law to exist on its own term, or will it always reside in the shadow of the Constitution? I invite you all the reflection on this. Is legal pluralism, South Africa, a true strength, or it is a contradiction that we are still yet to confront? And in conclusion, I say that I refer to these events as the Satan uncertainty. What I mean by that, on the certainty part, is that while the people in 1962, they arrived in South Africa, the certainty part was that they accumulated resources for their own personal use and for their own personal benefit. But the uncertainty part is that within the expense of the black people in South Africa. Therefore, I thank you all. I may now take my leave.
Prof. Ntlama, see the work of your hands. It is very inspiring to see our students really engaging and taking part in these critical discussions. Thank you, Mr. Pikashe, for that very insightful and thought-provoking presentation. I will now call on Ms. Maria Shanga Maseka to present on gender and customary law.
Greetings to the House at large. My name is Maria Maseka, and I'm currently doing my second year in LLB mainstream program. Today, I'm going to focus on the topic of gender and customary law. So I'll first start in the introduction by defining what is customary law. Customary law are the customs and usage and tradition that are traditionally observed among indigenous African people of South Africa and forms the culture for those people. So one of the particular continuous areas of customary law that promotes gender inequality for women's rights are customary practice involved with succession, inheritance, and polygamous marriage. So the law of succession realized in customary law have received severe criticism both before the 1996 Constitution and after. So polygamous marriage is a practice in customary law which offers a privilege to male whereby they can get married to more than one wife. So the recognition of customary law by the Constitution, as we know that Section 2 of the Constitution does provide that the Constitution is the supreme law of the Republic. So Section 211, subsection 3 states that the court must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. So moving to the challenges in customary law of subsection on gender. So many cultures in customary law traditionally practice patriarchy, which offers male greater legal privilege and rights whereby more than women, whereby there are certain rules such as male cannot be succeeded by a woman, the principle of male primogeniture, and the allotment of property, which can create gender inequality when it comes to males and females in South African customary law. So in the case of the principle of male primogeniture and allotment of property, which create gender inequality when it comes to male and females in South African law, it was a challenge in the case of Bear versus Magistrate of Khayelitsha, because according to the provision of the Black Administration Act. So this was declared by the Constitutional Court to be unconstitutional because it does violate the right of equality based on gender. The rights of equality on Section 9 of the Constitution based on the grounds of gender, race, color, and ethnic rights to dignity, as well as Section 10 of the Constitution with the rights to dignity. And further, the Constitutional Court also, in regards to in terms of Section 39 of the Constitution, they interpreted this provision of the Black Administration Act because it was inconsistent with the Bill of Rights, whereby they had to promote the objectives and purpose of the Bill of Rights. Moving to polygamous marriage in customary law, polygamous marriage is when a man gets married to more than one woman. So the Recognition of Customary Marriage Act 120 of the 1998 gives rights for a husband to get into a polygamous marriage with the approval of the court, as well as the wife's consent, which was confirmed or emphasized in the case of Mielani versus Ngwenyama. However, this provision may be discriminatory to a certain extent because it only allows for polygamous marriage for men, but does not allow for polygamous marriage for women. Therefore promoting male primogeniture and raises concern about gender inequality and the rights of women in customary marriages. The importance of equality in gender is to promote fairness, strengthen families and communities, encourage participation of both men and women in governance. So the importance of gender inequality in customary law was evident in the case of Shulubana and others versus Namita, where the court held that contemporary practice of the Valois reflected a valid legal change that resulted in the applicant's succession to the chieftainship as a result of the traditional authority development of customary law in accordance with the rights to equality. In conclusion, the intersection of gender and customary law in South Africa presents a complex challenge because customary law is part of the South African law, and most customs are patriarchal, which discriminate against women. So the Constitutional Court ruling in Bear versus Magistrate Court Khayelitsha versus Shulubana and others, Namita case aim to address these issues and challenge in order to balance between customs and human rights by promoting gender equality and dignity in customary law. The reconciliation is possible through careful adoption and reform, ensuring balance with customs and human rights. Also, by promoting greater gender equality, there must be an involvement of human rights principle and the state should regulate customary law in a way that is compliance with human rights and equality and non-discrimination. Thank you.
Thank you very much, Ms. Maseka. I think let us continue to the second session, or should we rather, I think let's take questions for this panel before we proceed to the next session. There were some questions that were posed by our panel, and I hope that we will get some answers from the audience, as well as some questions. So I would like some roving mics on the floor from my colleagues, so that we can take questions. We'll have 2 rounds of questions. I'll take 3 questions per round, and then we'll see how we proceed from there. Okay, we have a question at the front. Let's take your question, so long.
So thank you very much for the very interesting presentations. I was struck by the differences between Mr. Bakashe and Ms. Maseko's view on the Bay case. So I was wondering how each of you view, or how you would respond to the position of the other person. So in other words, the argument that the Bay case actually fixed a problem of gender discrimination, and for you the argument that by doing so it negated customary law and at the expense, or it valorized constitutional law at the expense of customary.
Okay, so I would like to take the question, because in as much as I didn't quite grasp what was the content of it, but to respond to what she was actually addressing. So I would say that now the status quo is to acknowledge those provisions of the Constitution, to say that in as much as she alluded that those provisions are trying to redress those patriarchal norms, which are Eurocentric conception. So I would say that for us to actually strike a balance in between, we need to understand the customary law application from its own background and from its own conviction of what a particular community or a particular racial group state what is customary law is.
I didn't quite get the question. Can you please repeat? Okay, from my understanding, I agree with him based on the case of Bear versus Magistrate Court, because he specifically mentioned how about Section 23 of the Black Administration Act, how it was unconstitutional. So these provisions together, they fall the same as well in the topic of gender, because as it violates from in the rights of the woman. Yes, thank you.
Thank you. My name is still Kosumini Nkulujoy. I think in my case, I wish to give a scenario. We've got a dispute of a young female who wants to take over the reign. Yet the custom states that it is the male progeny, of which the reason why it's so is because as you are the reigning, you then become the head of that clan, whereby there will be customs that you will be leading. So in that, you are then the male who would be afforded that that role to do that, of which you can't. You can't as a female. Can that be justified? That due to the fact that you are the male, you are the leader of that clan and the reigning, you are the only one that can do it in that gender, whilst the female cannot. Can it be justified in that way into the common law?
Okay, I can say that I'm not quite sure on the lens of the common law, but I want to delve on the lens of the Constitution. I would say that that can be justified because we can see our Constitution embodies like a subsection which provides for substantive equality, which allows us to redress those injustices of the past through justifications. To say that, I want to go back to what I initially stated, that what is important for us is to actually go back and understand the concept of to which, why was that specific application of a person leading the country was what's convicted within that particular community. So in the lens of the Constitution, and acknowledging that now the customary law is recognized within the Constitution, now the question is, the answer to that is, it can be justified under the substantive equality to say what the rationale behind of establishing that, and all those reasons that are customary in nature to understand that particular conviction of saying that this is how this thing ought to happen. So I think it can be justified.
With reference to the case of the Shulubana and others versus Namitwa case, in my understanding, I don't think it could be justified, provided that there should be reasonableness. Looking at the male primogeniture, whereby a male cannot be succeeded by a woman. What is the purpose for those rules? And like we look at the nature as well of the equality, the right to equality. Like, is it fair? Is it fair for both the genders, both males and females?
I just greeted, and for those who were not here yesterday, I am Kaukop Khami or Chief Khami, and I was saying I'm blessed, and my question is perhaps not too much in line with your presentations, but due to the nature of the age group of the panel and due to the complexity of the current state of affairs when it comes to these left-wing breakaway groups establishing themselves under the notion of constitutionalism and under the notion of their customary laws. And I'm referring primarily to Orania and Kleinfontein. Now, Orania and Kleinfontein is left-wing groups that separates themselves and calling themselves as Afrikaner groups, but indigenous because of the name Afrikaner. My understanding of language, and this is where I differ, my understanding of language is we are all deeming ourselves African by virtue of being descendants of Africa, while those groups, they call themselves Afrikaner, yet they don't descend from Africa, which is just an Afrikaans word for African, which means that technically they align themselves as being African. And now I'm asking this because they say that they are practicing their culture. Now, if they practice their culture, classify themselves as African, but not to the extent as you classify yourself as African, but classifying themselves as African in the term Afrikaner. Now, does customary law apply to them, since they call themselves cultural settlements, descending from Africa, but not from Africa in its originality, but as colonialist settlers who settled themselves in Africa, now claiming to be African by virtue of that, do you consider them as population groups that can be assimilated or absorbed, not assimilated, absorbed into our customary law systems, since they see themselves as traditional communities to their own right? And this is where constitutionalism fails us as Africans and not Afrikaner, because constitutional law gives that platform of self-determination and all these other things that everyone grabs hold of. My question is, in your understanding as youth, that the day when I pass, you will take over the reins of the leaders of this country of ours. So therefore, our legacy and our views should be in synchronization, so that when we pass, the same views are expressed. My question to you is, do you consider them as part of indigenous communities, and do they apply, and do you see them as being part of customary law in their own right? Thank you.
Okay, from my own understanding, I don't want to give a direct answer as to yes or no. But I'm just going to provide a controversial answer, because for like both advantages for that and both disadvantages for that. So first, I want to acknowledge the fact that our constitution recognizes the international conception. So what we first need to do is to understand that there is international customary law, which we as South Africa need to abide by as well. So on those people residing to that particular place in the lens of the international customary law, I say that can be justified, and they can be. But as for the roots and the understanding of us as South African, because we said that in 1652, those people, Jan van Riebeeck and other Dutch settlers, they came in South Africa and interfere with the way in which we do our things. So now they cannot claim themselves as they have this recognition of customary law and wanting to be independent from what we currently practicing as the state as a whole. So this also goes back to us questioning our very own constitution, that why does our constitution states that South Africa belongs to all who live in it, instead of saying that the constitution belongs to its people? So that's the same very question that we need to ask ourselves, and how can we change that to understand these contemporary challenges of asking ourselves, what is customary law? Who can fall within the concept of customary law in respect of these traditions that we have and the diversity that we have in South Africa? So in as far as the constitutional lens, they cannot be recognized under the customary law. But for the purposes of respecting the international customary law, therefore that can be a dialogue that needs us as well to sit and ask ourselves, do they really need to obtain the status of them being recognized under the African customary law? Thank you.
Sorry, I don't know whether I will still be on what is being said, but first thing that I would like to say is that my challenge is regarding the constitution, because the problem that I'm having with the constitution is that, to me, seemingly it was never discussed with the citizens of South Africa. It was discussed with a certain elite that was opening its ways to the riches of South Africa. So that is why now we are faced with these problems, because some of the laws or legislations that are within South Africa, they conflict with our views, with our understanding of how we are supposed to be governed. So we are having that problem. That is why now some of the laws that were from the the previous governments, they are just imposed to us. Seemingly, our government didn't have anything in hand that, that they would bring to in order for the government to be right, but it's only to take from what was being done by the previous governments to the current government. So that is why we are faced with these problems.
Thank you. I'm Chief Dinoyo from Lusikisiki, Gauteng Kingdom. I'm interested in the right answer in the question that was posed by my colleague here, because they gave two different answers to this question. So if perhaps someone who's more senior who can give the correct answer, because this question is very pertinent to us as traditional leaders, and I would like to know the correct answer. Thank you. I don't know if you still remember the question. The question was about whether, can you please repeat it, my colleague?
No, the question was answered, but just to repeat it, it was more on the issue of discrimination of females that would want to reign in the case of our positions as traditional leaders. So once they get nullified due to the fact that the custom requires for a male who will also lead certain practices, certain customary practices that can only be led by the male. So now it then nullifies the female. Can that be justified because there is this custom that this one needs to do, being the male?
He said yes, she said no. Now I'd like to know which is the correct answer.
Okay, thank you. My name is Obrile Dwaba. My answer is simply that, in the judiciary, if you look at the history of our judiciary, there was a perception that only men can be judges. And it later turned out that that was a wrong understanding of who can be judges. And things have changed now. I think we've got about, if I'm not mistaken, about 49% of the women are judges. In the magistracy, women are in the majority. So the judiciary is an example to show that women can still play leadership role in certain instances better than men. Thank you.
Yes. Thank you, Jablis and Matondo. No, there's a legitimate purpose for so doing. It's not that the person is simply appointed because he happens to be a man. This chieftaincy or kingship should continue. It must continue in the correct bloodline. So if a female takes over, she's going to marry someone to another clan. In order to prevent her from going with this royalty to that clan. So it must be a male. And also we must have a family tree. how can you have a family tree? Because there's no continuity down the line. The lady will marry somewhere else. Nobody, I don't think this clan will allow that lady to take away that chieftaincy or kingship to another clan. So that's the reason. It's not that because she's a woman, she cannot. Because she can be a regent. She can be a regent for somebody who's still a minor, or until an appropriate person has been identified. Then that person should take over for that reason, not for equality reason. Even in that case of Shulubana, that the young lady has referred to, the Constitutional Court realized that it made a mistake, because it eventually concluded that neither the sons or daughters of that lady who was appointed could succeed. Only a sociological child, meaning that the child with the bloodline of Namitwa should succeed. That's the clear indication that the main reason is the continuity of the bloodline. But some other people are just carried away with equality clause and so on. It's not what it is. So while I'm still on the floor, I move on under this gentleman, this is Bigashi. Bigashi, I have heard. Firstly, I have to commend you, young people, to enter into this arena and make your views and all those things. That is really encouraging. You comment that the Constitution has recognized the customary law. That is a fact. It is not, we are no longer now crying for the recognition. But the second question, the question you posed is whether the customary law is applied to its full context. I think that's your question. So I may ask from you, how should we go about to ensure that the customary law is applied to its full context, or in the way it should be? Thank you.
Thank you very much, Judge. I think let's take this discussion to lunch, maybe, in the interest of time. Maybe there isn't a right or wrong answer, which reinforces why it's important for us to have these discussions. And I see that we have more questions than we do answers. So let us continue the conversation. I would like to urge our colleagues online, Ms. Professor Fatima Osman and Mr. Boyane Tshehla, to just stay logged on. Our second session will take place in this venue, so colleagues will not be moving to another venue. And I'd now like to hand over the reins to Mr. Chikota to lead us in the second session. Thank you very much.
Thank you very much. Molweni. I see people are angry at me. Today, I promise I'm here on a very simple issue. I'm not going to be doing those things of yesterday. So I will say again, Molweni, Ninjani. Akonto. So let me just quickly. Okay, molweni, ndimacheloni, sanbonani. My name is Kodani Chikota. I'm from the Sachi Chair in Equality Justice at the University of Witwatersrand. So the session that I'll be chairing deals with customary law and restorative principles. So can we please clap hands for our panel as they go to their seats so that we can accept other panelists. So I'm recognizing all the dignitaries, judges, retired judges, the chiefs, dean, and all protocol observed. So on the surface, these two systems, that is customary law and restorative principles, they seem perfectly aligned as they both aim to protect and promote human dignity, equality, and justice. In fact, customary law formed the foundation of restorative justice in South Africa. For example, the Truth and Reconciliation Commission was guided by Ubuntu as enshrined in the interim constitution, a principle later reinforced by the Constitutional Court in the Makwanyane case. Yet in practice, clashes remain. Questions of equality in customary law and certain customs such as ukungena often conflict with restorative justice principles. The central question we face is, how do we harmonize customary law with restorative principles in a way that is fair, inclusive, and rights-protecting? Fortunately, as I had already alluded, today I am not the one doing the answering of questions. I will now call upon our distinguished panel to delve deeper into this important discussion. The first panelist is Mr. Mboyane Tshehla from the Northwest University. And the topic is disempowerment and or undermined, traditional leaders and the state's ambivalence towards traditional justice in South Africa. Is Mr. Tshehla in the room? Oh, online, okay, we've noted that. Then we have, can we also clap for online panelists? Then the second one, also joining online, we have Professor Fatima Osman from the University of Cape Town. And the topic is, Where to with matrimonial laws and gender equality in South Africa. The third one is Temuso Malachi from University of Fort Hare. And the topic is, Customary Law and Gender, the Legality of Ukutwala, Violating Women and Children's Rights. Can we all clap for her as she makes her way? Thank you very much. The fourth speaker is Mpho Cynthia Rat from the University of Fort Hare, and the topic is gender equality in the context of customary law and customary law, bridging tradition and justice. Our last speaker is Ms. Nkuzo, also from the University of Fort Hare, and Ms. Nkuzo. Thank you for the correction. The topic is evaluating the role of traditional leadership in local governance and customary justice systems, a case study approach. Okay, thank you very much. Mr. Tshehla, can you hear me? Mr. Tshehla, going once. Okay, as he is still arranging these things of technology, let us welcome Professor Fatima. Professor Fatima, over to you.
Thank you. Good afternoon, everybody. Am I audible?
Yes, yes, perfectly.
Okay, that's perfect. So good morning, everybody, and thank you for this opportunity to share some of my views with you about my research into South African customary law and marriage. My name is Fatima Osman, and I lecture African customary law at the University of Cape Town. Today I'm going to discuss something a little bit off topic of what we've been discussing thus far about traditional leadership, but it deals with customary law marriages, an issue that affects millions of South Africans. And what I'm going to talk about is a new era of discarded wives and the way forward for them. So as context for this discussion, there are two things that need to be noted and kept in mind. First, historically, in the pre-constitutional era, customary law marriages were not recognized as valid marriages in South Africa. And this historical position continues to influence how people regulate their lives. There is a pervasive belief that customary law marriages are not lawfully recognized. Secondly, prior to 1988, customary marriages did not prevent a man from entering into a civil marriage with another woman, and thereby superseding the original customary marriage. This created what we termed a category of discarded spouses, women who were left without any formal marital rights. What was surprising was that even the apartheid regime, the courts also extended ad hoc protection to customary spouses and recognized the duty of support. So even the apartheid regime, with its disdain for customary law, extended some protection to discarded spouses. And this is a point that I'm going to return to later. We fast forward a couple of years and we reach the year 2000, where the Recognition of Customary Marriages Act comes into force. But it hasn't been without its problems, and it's created a new era of discarded spouses. The first issue arises because of the flexibility in the requirements for a customary marriage. Section 3 sets out the requirements, and the most important is that the marriage must be negotiated and entered into or celebrated in accordance with customary law. This has been interpreted to mean that there must be a negotiation, an agreement or payment of lobola, and the handing over of the bride. Now, people have interpreted the requirements to argue that the requirements are applied as rigid binding rules, and the failure to fulfill one negates the existence of the marriage and ultimately a woman's marital rights. They've also sought to use the common law rules of precedent to argue that judgments are absolutely binding, regardless of whether you are dealing with another community or observe a different set of customary law rules. The result is that women who believe that they are married, live with their partner, have children with them, find that their partner or his family would deny the existence of the marriage because the requirement has not been complied with in full. It leaves women in a precarious and vulnerable position, as the validity of the marriage is always under threat. In a response, the pendulum has swung the other way, and our courts have almost adopted a family-specific approach, which allows families to decide whether the requirements must be fulfilled and how it must be done. The result is a varied approach, where sometimes handing over and lobola is required, and sometimes it can be waived. It reflects the idea that there are no rigid rules for the conclusion of a customary marriage, and communities and families can decide how the requirements apply. But it has also led to uncertainty about what the court requires to recognize a marriage, and it has resulted in frequent challenges to the validity of marriages. The second issue arises because there is no polygamy across marital systems. So the Act doesn't allow for polygamy across different legal systems. A husband cannot marry one wife under customary law and another under civil law. A civil marriage remains strictly monogamous. This, however, overlooks the social reality that it happens all the time, especially in South Africa, because of the pervasive belief that customary law marriages are not valid. And so people often conclude civil marriages with third parties, not believing the customary marriage to be valid. And because registration is not compulsory, there's no written record, and it's impossible to find out about the existence of the marriage. It's exacerbated by Section 8 of the Recognition Act, which requires a court order of divorce. Now, it's counterintuitive. You can conclude a marriage without any involvement from the state, but obtaining a divorce requires a court order. And without this order, parties remain married and lack capacity to conclude a further marriage, and any subsequent civil marriage is invalid. So the Recognition Act ironically creates this new category of discarded spouses: those who cannot prove the existence of the marriage, or those whose marriages are invalidated on a technicality. And this is quite harsh, because the Act doesn't offer any protection to the spouse in the invalidated marriage, who is arguably in a worse position than the pre-1988 discarded spouses above. I examine whether there are existing legal mechanisms that may be used to protect parties who find themselves in this precarious position. The first is a putative marriage, where void marriage is visited with limited legal consequences to mitigate the harshness of the annulment of the marriage on the innocent spouse. The requirements are simple in that the marriage must be solemnized, one or both parties must be unaware of the impediment that would render the marriage void, and both parties must have considered the marriage to be lawful. I argue that the putative marriage offers some recourse to a customary law spouse whose marriage is invalidated. Ultimately, though, the court needs to have discretion about what is just and equitable in making orders about the distribution of the marital property, taking into account the circumstances of the case. The second alternative is a universal partnership, which has been used frequently in the common law to help spouses in unrecognized marriages. Parties can claim a division of the matrimonial property. Now, South African jurisprudence recognizes both the commercial and non-commercial contributions here, like finances, skills, time, effort, childcare, homemaking. And so it becomes an important legal tool to protect parties' rights that's unfortunately been completely overlooked in the customary law context. Finally, we come to the issue of life partnerships, where historically South African law has drawn this distinction between married and non-married partners, and held that the law can grant benefits to married partners that it doesn't confer on unmarried partners. But the Constitutional Court in Bawanya has blurred this and declared the Interstate Succession Act and the Maintenance of Surviving Spouses Act unconstitutional, to the extent that they exclude partners in permanent life partnerships who have undertaken reciprocal duties of support. And so parties in invalidated customary marriages may have claims for inheritance and maintenance if they can prove that their relationship constitutes a life partnership. There are no fixed criteria, but it generally is thought to include an unmarried monogamous couple who cohabitate in a lasting union. The courts are going to consider financial commitments, sharing of property, the duration of the relationship, and the presence of a celebratory ceremony. To conclude, our case reports are filled with disputes regarding the existence of a customary law marriage. What is shocking is that in these cases, attorneys do not plead alternatives, such as the existence of a putative marriage, a life partnership, or a universal partnership. Now, it may be true, and it's of course the right of parties who want to have their rights recognized in customary law, who want to have their customary law marriages recognized and as valid. But we must respect the rights to also protect vulnerable parties who often have their marriages invalidated through no fault of their own. The use of these alternatives may also protect and guard against stretched findings on the law. So we've seen our case law filled with findings in which courts have recognized customary law practices like the waiving of lobola or the waiving of handing over with very little evidence to support it. The stretch finding is justified on the basis of protecting women's rights, but it ultimately undermines customary law. What we need ultimately is not to see the law in silos and to consider all available legal mechanisms to assist vulnerable parties. And that while we should be moving towards a more holistic approach in family law, in the interim, we should use these other legal mechanisms to protect people's rights and hopefully also guard the true nature of customary law. Thank you for your time.
Okay, thank you, Prof. Fatima. Yeah, that was a great presentation. I think the issue of the validity of customary marriages is one of the most contentious issues right now in South Africa. We even saw it with the famous late HP, where there was only lobola, and then the debate was he married? Does the wife have a claim, and so on? So thank you for that, and we're hoping for more discussion during question and answer. So I'm going to then revert to Mr. Tshehla, as he has highlighted that he is now available and apologized to that regard. Mr. Tshehla is from the Northwest University, and his topic is disempowered and or undermined, traditional leaders and the state's ambivalence towards traditional justice in South Africa. Over to you, Mr. Tshehla.
I hope you can hear me now.
Yes, very well.
Oh yeah, thank you very much for the opportunity. And I must firstly apologize for not making it to be there in person. I would have loved to be in that part of the country. Must I add, beautiful part of the country. That said, I'm grateful that I could connect and listen to the presenters before me, and they have indeed covered the most interesting parts, I think, regarding the topic at hand, namely customary law, traditional leadership, and in particular, the legislative mechanisms that attempt to deal with it. Now, I'm going to try and be brief in my presentation, and I must disclose immediately that I piggyback on a dated research, as it were, somewhere mid-2000s, around 2004, 2005. And usually the fact that research is old would mean that it doesn't actually tell us a lot. But in our case, it does hopefully bring value to the current discussion that we're having post the enactment of the Traditional Courts Act. Now, I'm going to divide quickly this presentation into four main headings. And the one will be constitutional recognition, which is what I think has been dealt with this morning by many of the speakers who went before me. And then I'm going to quickly also deal with judicial development, and then move quickly to challenges and uncertainty. Then I'll conclude with gender and fair process concerns that come with the measures that are being introduced to try and regulate the field of customary law, African law, you name it, and I think that structure is provocative in nature, in the sense that it says to us, at the very basic level, it says, yes, there have been constitutional developments. Yes, our constitution recognizes customary law, and it calls for its development. I think there's no gainsaying that. But then I think the real issue becomes whether or not the path that we are following in doing so is the correct path, or is the most appropriate path to try and deal with customary structures such as the previous speaker just talked about the problems that are experienced in the field of customary marriage. So let me get to it without going into detail. I think everyone, probably, even lawyer or no lawyer, would know that the Constitution, our Constitution recognizes customary law. And it does so, and you can look at, among others, Section 211, and you can also then, when you're dealing with courts, go and look at Section 165. The attempt of the Constitution, that is, the attempt really there is to try and create mechanisms within the existing system, which is Western in its format and practice. The quest there is to try and cave some space, as it were, for customary law. And I'm saying, is it how it should be done? We have a system, and we go around finding ways in which we can be, or we should be, accommodating customary law. Now, the first step, I think, after the Constitution, to try and deal with the issues, tradition in nature or customary in nature, was, of course, the now repealed Traditional Leadership and Governance Framework Act, the one enacted in 2003. May I just hasten to add that it was only in 2003 that this was created, having had our democracy start in 1994 and the Constitution in 1996. So it did take some time. And lo and behold, as we're talking now, it has been repealed, and we have the new legislation that was meant to replace it, having been declared unconstitutional in the seminal Morale judgment. Now, that is it in terms of the measures that were taken in respect of recognizing traditional leadership. Now, traditional leadership goes with traditional justice, obviously, because it is traditional leadership that leads traditional justice or traditional justice mechanisms, or including traditional courts. Now, what is it that was done in order, after recognizing traditional leadership, as they should have, what is it that was done to try and, as it were, accommodate traditional justice? Because the way I think here is accommodated. Where can we fit it? And as I'm saying, that is not how things should happen. But that is a story for another day, I think. But it took almost 30 years before we have a statute that focuses on traditional justice. And that is where the study that I highlighted of about 2005, which I did in Limpopo, a village, Kekana, led by Khoshi Kekana in Limpopo, and the one in Moleji. And it showed how people struggle on a daily basis to try and make sense of justice. Disputes will always be there. Now we have people trying to deal with disputes in an environment, and I called it that, and I think it's fair, in an environment of fear and uncertainty. Now, they always told that what you are doing may be unconstitutional. And they say, but what will be constitutional? We need to know what to do. The answer was not coming. And what is an attempt at an answer is the 2023 Traditional Courts Act. It came in and it has attracted a lot of flack. And I think it deserves every flag that it gets. It's like you make someone to wait for about 30 years, saying you are baking a cake, and when it's time for delivery, you give them something half cooked. So the time spent and the product do not match. Why do I say that? And why do I sound so negative, as someone has told me before? It is not being negative. It's seeing it for what it is. Because you don't have to go far to see that the statute itself does not move us much further than where the Black Admin Act had left us, the one of 1927. So if anything, and some have rightly argued, we have taken a step back in terms of recognizing and validating traditional court. Now, why this? Number one, what is traditional dispute resolution and how do traditional leaders deal with it? They deal with it following restorative justice. They do it without that linear distinction between law of delict and criminal law. Now we have a statute that comes and tells us that there's got to be that distinction. Why am I saying that? Despite clear wording in the statute, because it does say to us that there will be limited jurisdiction in respect of criminal matters. So already there is that approach that says and assumes that the distinction exists. And I think that may be misleading. Now, at the core of restorative justice, the one that at least the traditional communities I know practice, there is very little distinction in terms of the label to a case. For instance, a case that is seen in the Western sense, for instance, say assault with intent to do grievous bodily harm, may end censure that is not as serious as a case in which someone is accused, and I'm going to use that example, for murder. And people think that is something that works against traditional justice. Actually, it doesn't, because traditional justice always goes to the root of the problem, not the result. In other words, it's not much what has been done, but what caused it to happen, to deal with the root duties. And I say and challenge the drafters of the statute and those who apply it to tell me that this statute actually covers that particular perspective from traditional justice. Now, that is the one, but the second part is it has got flack because of this. The one part is they're trying to restructure the systems of justice in a community to say there should be records, there should be training of presiding officers, and of course they say to us there will be regulations later, which is fair because the statutes can be followed by regulations. But I think you don't produce regulations for something that doesn't already stand on its own. May I just ask the facilitator that I tend to lose grip of time. Could you just maybe indicate in a message if I am out of time, or just shout at me?
Yes,
okay.
3 minutes as you close.
Sorry?
3 minutes as you close.
Okay, all right. Let me use the 3 minutes hopefully productively. The one is, I am saying there is this issue of gender equality. And I am for gender equality, by the way, and I think it works. But the question is, how does gender equality work in a situation where we have entrenched patriarchy? How do you deal with a woman who is made part or is appointed or elected as part of the traditional council, and inside that council, they are told that, look, you've got to speak after I have spoken, for no other reason except that I am a man. Those are some of the issues and realities that are not dealt with at that stage. And finally, as a final point, and I hope this links everything together to what I call neglect of traditional justice by the current government or our current democracy. Let me put myself in that as well, because what happened was there was this time about 30 years, yes, and they come after 10 years, or we come after 10 years and we say, here is a statute. The real question is this: what has been happening to customary law in that vacuum, in that 30 years? Because you come and regulate it as if it has been static. It has not. Now, my study in 2005, admittedly long time ago, and some other studies do indicate that this justice or form of justice has been changing in various respects. Now, can we stand here and say today that we think our statute that we have waving around has got or recognizes the reality that customary law is not that which some of us were taught equally about 30 years ago when we went to first studied law? Right, that is the one part. Unfortunately, and I've got to bring this in, it is not only traditional justice that is suffering from this neglect from the state. It is also other forms of traditional aspects of life. I work in the field of traditional health practice, and believe me, the problems are worse in there. It made me conclude that everything traditional is not taken as seriously as it should, and maybe we should introspect. I know I did not touch on many things. I could have gone into the case of Shilobana, I could have gone into the state of Mutlekwa, I could have gone into the case of Mugali and all those things. But I think at the end of the day, these are the things that are in my paper, which is complete. They will come out there, but this, with the time limited, I touched on what I see as the key issues. And I intended to raise questions that this colloquium can raise. If the organizers wanted to come there, there is detail about each of the topics that I highlighted here today, and I thank you.
Okay. Thank you so much, Mr. Tesa. Please don't leave, because I'm sure there are many questions. Also, Prof. Fatima, we have 3 panels that are going to discuss, and then so after that, we'll just take questions overall. So key takeaways: customary law to be accommodated or afforded equal status with common law. Should it have to fit in or stand alone? How do we deal with the issue of these patriarchal institutions that we are putting women into? As we think about those questions and prepare our questions, I'm going to call, I don't know why I always leave this paper. I'm going to call Temuso Malachi from the University of Fort Hare, and her topic is Customary Law and Gender, the Legality of Ukutwala, Violating Women and Children's Rights. Yeah, over to you. Can we please clap hands for her?
Greetings to the house at large. My name is Temusho Malachi, and I am a final year student at the University of Fort Hare. I'd first like to say Happy Heritage Day to all of us here, and I am very happy to see that my culture has also been represented by all advocate there. So Mapedi, forward good. My topic for this colloquium is customary law and gender. I will be focusing more on ukutwala, a practice that after so many years in some parts of the world is still being practiced, even though it has been declared unconstitutional and and it has been proven that it contravenes so many laws, not only in South Africa, but globally and internationally. So customary law practices have been long criticized for limiting women's rights, particularly their equality, dignity, and body anatomy. Traditionally, these systems were shaped by patriarchal norms that placed women at a disadvantage in areas like marriage, inheritance, community leadership, and it was giving men more privileges over women. As a result, many customary rules continue to conflict with human rights principles of gender equality. Although South Africa has tried to reform the customary laws to align with constitutional values, women in traditional communities still face obstacles limited to formal justice, and reliance on traditional leaders often make constitutional rights difficult to realize in practice, especially in the rural areas. So ukuthwala, firstly, is a form of adoption in which a man, along with his friends, peers, or family, kidnaps a young girl or a young woman with the goal of forcing her family to approve of marriage proposal. This particular practice is most common among the Nguni. Ukuthwala in the Nguni community was a socially acceptable but unusual route to marriages that was intended for specific girls or women who were ready for marriages in ancient Africa. However, until the marital criteria were fulfilled, there was no sexual intercourse happening, there was no rape, there was no coercion, until all the marital criteria were fulfilled. Ukuthwala is a customary practice that has its origin in South African culture, especially in the Xhosa and Zulu communities. It has received a lot of attention in the modern world because of how it links the relationship between cultural heritage and human rights. In the past, this practice was thought to be a way for families to quickly make marriage arrangements or to get a bride when formal discussions were seen to be impractical. Ukuthwala is an intricate part of the social structure of many cultures, reflecting cultural norms around gender roles and family responsibilities, in addition of acting as a way of marriage. It was viewed as a noble deed that strengthened familial and communal relationships of cases where women were taken against their will under the pretense of this tradition, which raises important questions about how to strike a balance between upholding individual rights and respecting cultural rights. According to Ulia Mwambene, in her 2009 research, she stated that in 2009, mostly in the Eastern Cape province, in cities like Lusukisiki, Flagstaff, Bizana, and the Eastern Pondoland, under the practice of ukuthwala, girls under the ages of 12 and 15 were forced to marry older men who most of them were HIV positive. Approximately 89 girls from these places that I've mentioned were hiding in areas in Gauteng and KwaZulu-Natal out of the fear of being victims of this practice. The supporters of this practice defend it as a traditional cultural practice, arguing that it permits a man to adopt a woman he wishes to marry, even if he has not proposed love. This adoption particularly occurs when a young girl goes on their way to school or fetching water or wood. This has been this statement has been critically discussed by many authors, saying that romanticizing ukuthwala is the same as saying that you must being in an abusive relationship shows that the person loves you. There are types of ukuthwala, which the first one is consensual and is essentially similar to elopement, where the woman and the man both agree that they want to get married. The second one happens with the second one occurs when the family arrange the marriages without the knowledge of the girl, and she must initially consent. The third one is the most problematic. This is the outright abduction of a girl, which is accompanied by rape, coercion, and violence without the consent of the girl. So several instruments have been used to fight the practice of ukutwala. The first one, the international one, is the Universal Declaration of Human Rights that affirms that marriage must be entered into with the free and full consent of both parties. The Convention on the Right of the Child further highlights that children's rights principles such as best interest of the child, protection against abuse, and the right to be heard must take preference. Similarly, the Convention on the Elimination of All Forms of Gender Against Women calls for elimination of child marriages, and the Marriage Convention also requires free and informed consent in marriages. The African Charter is clear that in prohibiting child marriages, setting 18 as the minimum age expectancy, and the protocol of the African Charter on the Rights of Women requires states to legislate against discriminatory and harmful practices. We all know that ukutwala goes against the many the Bill of Rights that are enacted in the Constitution. I've been told that I have a limited time, so I'm going to enter now into the debate on the legalism or criminalization. The supporters of the practice argue that it is a part of cultural identity and should be preserved under Section 9, subsection 3 of the Constitution, which protects cultural rights. They suggest reform rather than prohibition, with communities adapting their practices to respect, consent, and agency. Supporters of this thing further argue that banning ukutwala may alienate traditional communities and undermine cultural governance systems. However, those in favor of criminalization states that the practice violates women's and children's fundamental rights. It undermines their equality, dignity, education, health, and further fuels gender-based violence. In conclusion, ukutwala represent the tensions between cultural tradition and modern human rights framework, while historically it had consensual and symbolic forms. In contemporary practices, it has become synonymous with coercion, violence, and exploitation, leading further to gender-based violence. In this form, it violates constitutional provision, national legislation, and international and regional human rights treaties. Although some advocate for its prevention as a cultural practice, the current abuse associated with ukutwala aligns it more closely with gender-based violence than with legitimate custom. For this reason, the practice as it exists today should be considered illegal. At the same time, should be made to reform cultural tradition in a way that respects both heritage and fundamental human rights, ensuring that culture is not used as a shield for abuse. Thank you.
Okay, thank you very much. Is it still culture if it's harmful? I think that's the most important question that we have to ponder on. I remember there was a protest where someone who was involved in ukutwala was arrested. So the people who were outside, someone was being asked, why? But it's your culture. And then he was like, if it was your child, you would understand why I'm here. As we move on, those are questions that we have to ponder on while they are presenting. As we move on, we're going to go to speaker number 4, which is Mpho Cynthia Rat, also from the University of Fort Hare. And her topic is gender equality in the context of customary law and customary law. Okay, bridging tradition and justice. Can you please clap for her?
Thank you so much. Greetings to the house at large. Dumelang, Molweni, Abshen, Happy Heritage Day. My name is Mpho Cynthia Rat, a second-year LLB student at University of Fort Hare in East London campus. I am passionate about human rights and the power of legal reform. I believe that law is not just about rules, but it is about transforming the society and restoring the dignity where it has been lost. My journey is inspired by the belief that justice should reach everyone, irregardless of their color or background. My topic for today is gender equality in the context of customary law and bridging the tradition and justice. Customary law is one of the oldest forms of law in South Africa. It's unwritten, passed down through generations and rooted in the values of our indigenous communities. It governs marriages, inheritance, land and leadership. But while it brings unity and identity, it also brings challenges, especially for women. In many rural areas, women are still excluded from inheriting property, making decisions, or leading their families. This presentation, it explores how customary law affects gender equality and how we can reform it to reflect the values of Constitution, values like equality, dignity, and the justice. The goal is not to erase tradition, but to help it grow into something that uplifts everyone. Customary law is a living system. It's not written in books, but it's written in the way we live, the way we marry, the way we bury, and the way we lead. It's based on the traditions of our indigenous communities and has been recognized by Section 211 of the Constitution. And that recognition, it comes with the condition. The condition is that customary law must align with the values of the Constitution, which also means that it must respect the human rights. Customary law teaches respect, unity, and belonging. But when it forgets the right of human, it becomes a shadow of what it was meant to be. We must ask ourselves, can a law that excludes half of the population truly reflect our values? Or is it time to change it? Gender and customary law. Gender inequality in customary law is not just a legal issue, but it's a lived experience. In many communities, women are still denied the right to inherit property, to lead families, or to make decisions about their own lives. Section 9 of the Constitution, it provides that everyone has a right to equality. But in practice, many women are still treated as less than equal. Customary law often places men at the center as leaders, as the decision makers. Women are expected to support but not lead, to give but not to own. The imbalance is not just unfair, it's unconstitutional. And it's time we change that, because when women are empowered, families grow stronger, community becomes more just, and tradition becomes a source of healing, not harm. In the case of Bear versus the magistrate Kaelisha, the court was faced with a difficult question. The question was, can a rule that allows only men to inherit under the customary law still stand in a country that promises equality? The answer was clear, it was no. The court ruled that the male-only inheritance was unconstitutional. This decision was more than a legal victory. It was a message to every woman who had been told that she was not enough. It reminded us that tradition must work hand in hand with justice, that our customs must reflect the dignity of all people, not just some. This case, it opened the doors for women to claim their rightful place, not just in law, but in family, in leadership, and in legacy. The legislation reform. The recognition of Customary Marriage Act was a turning point. Before it, many women in customary marriages had no legal protection. They could be married for raising children, building houses, and still walk away with nothing. This act changed that, and it gives the legal recognition to customary marriages. It requires registration. It gives women rights to property, maintenance, and protection. But laws alone are not enough. In many rural areas, women still don't know those rights exist. And even when they do, they're afraid to claim them. That's why reform must go beyond paper. It must reach the people. It must be spoken in the language of the community, and it must be backed by education, support, and courage. In some villages, women are still told they cannot inherit. Their voices matters less. Those are not just outdated ideas, they are violations of human rights. We must ask ourselves, why does inequality persist even when the law says otherwise? The answer lies in silence, in fear, in traditions that has not yet been transformed. If we want to real change, we must break the silence. We must empower women to speak. We must educate communities to listen. And we must remind everyone that equality is not a threat to a culture, but it is a strength. Preaching tradition and justice. Tradition is beautiful. It holds our songs, our ceremonies, our stories, but even the richest soul must be turned over sometimes so new lives can grow. Preaching tradition and justice means honoring our past while building a better future. It means asking hard questions. Can we keep our customs and still protect our daughters? Can we respect our elders and still uplift our women? The answer is yes, we can do both. We do both because tradition and justice are not enemies. They are two hands that can build a future where everyone belongs. In conclusion, this is not just about law. It's about healing generations of silence. It's about making sure that our mothers, sisters, and daughters are not just part of the story, but are authors of it. Customary law can be a tool for justice. If we let it grow, we are not trying to destroy tradition. We are trying to restore its soul. A soul that remembers that women are not a property. They are partners. They are leaders. They are the future. Let us build a South Africa where tradition and equality worked side by side, not in conflict, but in harmony. Let's talk, let's reflect. Let's imagine a future where a tradition uplifts everyone. I welcome your questions, your stories, and your opinions, because real change begins with real conversation. Thank you so much.
Okay, thank you very much. I remember yesterday the program director, who is also from Venda with me that side, Advocate Shandukani Mutunguru Ugoda, said they have the best law faculty. And I think the people who are here cannot argue that, based on the presentations that even second year, third year students are making. So can we please just give them a round of applause again? I'm hoping that we are noting our questions, because there is a bit of time before lunch for few questions. So I'm hoping for a very engaging session. The last speaker is Miss Mkuzo, as I was rightfully corrected by my elder, from the University of Fort Hare. The topic is evaluating the role of traditional leadership in local governance and customary justice system, a case study approach. Can we give her a round of applause?
Good afternoon, esteemed guests and colleagues, and allow me to say all protocols observed. My name is Pel Mkuzo. I'm a TOT lecturer at the Faculty of Law. I am LLD candidate. Given the importance of traditional leadership in our cultural heritage, I would like to explore its relevance and impact in modern governance. And the focus of my presentation is on evaluating the role of traditional leadership in local governance and customary justice systems, a case study approach. Why did the traditional leaders bring a ladder to the municipal meetings? And the question is because they wanted to take their role to the next level. Thank you. So the role of traditional leadership in local governance and customary justice system is a complex issue in South Africa with a rich cultural heritage and diverse traditional leadership structures. It is essential to examine the impact of traditional leaders on modern governance and customary justice system outcomes. And to give a brief historical background, traditional leadership in South Africa has a long and a storied history dating back to the pre-colonial era, and the institution of traditional leadership has evolved with various laws and policies shaping its role in modern governance. Understanding this historical context is crucial to evaluating the current role of traditional leaders. Now the roles, what are the roles of the traditional leaders? Traditional leaders played a significant role in local governments, customary justice, and community development, particularly in rural areas. Local governments and customary justice systems are interconnected, with the local governance supporting and integrating these systems to enhance access to justice and community engagement. On the other hand, the customary justice system is an integral part of traditional leadership in South Africa. It is based on customary law and practices which are often unwritten and passed down through generations. And the customary justice plays a crucial role in resolving disputes and promoting social cohesion in rural communities. Even though traditional leaders are not organ of states, they, however, perform functions similar to states' functions, especially in rural governance and land allocation and dispute resolution. As a result, their performance is often shaped by the systems that recognize, regulate, and support their authority. And this recognition is not absolute, meaning that their authority is conditional and limited or subject to constraints. What are the legal frameworks that support traditional leadership today? The systems that provide formal recognition and guidelines for traditional leadership includes Chapter 12 of the South African Constitution of 1996, which explicitly recognizes the institution, status, and role of traditional leadership according to the customary law, subject to the Constitution itself. Equally so, Section 212 of the Constitution allows national legislation to define the roles of traditional leaders at a local level, particularly in matters of affecting local communities. And we've got also a Traditional Leadership and Governance Framework Act of 2003, which defines roles and responsibilities, offers institutional support through departments like COGTA. And it also aims to integrate traditional leadership into broader governance structures. And we've got also a Traditional and Khoisan Leadership Act of 2019, which expanded recognition to Khoisan communities, although recently declared partially unconstitutional, and it's under review. Further, traditional leadership operates in a hybrid space, legal space, where customary law coexists with statutory laws, and we call that what is known as a legal pluralism. Thank you. And legal pluralism is the presence and the interact of multiple legal systems within a single social field. It recognizes that people and communities often live under more than one set of norms, rules, and authorities at the same time, not just one formal statute law, but also customary, religious, family, and transitional forms that govern behavior and resolve disputes. However, the mere existence of systems does not guarantee effective performance. The quality, clarity, and autonomy of these systems are very crucial. And what are the challenges that are facing the traditional leadership? The systems in place and constitutional recognition that are designed to enable traditional leadership, their effectiveness is often compromised by political and administrative interference, which significantly hinder the ability of traditional leaders to perform their roles and duties. Traditional leaders often serve as intermediaries between the state institutions and local populations, yet their authority, jurisdiction, and accountability mechanism are not clearly defined within the African legal and policy frameworks. So this ambiguity creates tensions between the customary and statutory systems, particularly in areas of dispute resolution, service delivery, and community engagement. Furthermore, concerns around gender equity, procedural fairness, and alignment with human rights standards raise critical questions about legitimacy and effectiveness of customary justice practices. And the role of traditional leadership in local governance and customary justice system remains contested and under-researched. Now, what are the opportunities for traditional leadership? Despite the above-mentioned challenges, there are opportunities for collaborative governance, meaning that strengthening the relationships between the traditional leaders and municipal officials can enhance governance and service delivery. And secondly, the community engagement, meaning that engaging with local communities can help to identify and address their needs, promoting development and social cohesion. And the last one is to promote the cultural heritage. Now, what does the study case say? In the Ngoshwa local municipality in the Eastern Cape provides a fascinating case study on role of traditional leadership in local governance. The municipality has a significant traditional leadership presence, which chiefs and headmen playing important roles in rural governance. And this case highlights the complexities and challenges affecting traditional leaders and municipalities as summarized as follows. Lack of recognition and cooperation between leaders and municipal councillors. Secondly, power dynamics. That is power struggles and elected council. They've got their own struggles. And limited role in decision-making, meaning that the traditional leaders have a limited influence and no voting powers in the municipal decision-making processes. Now, what are the consequences of that? The impact of political and administrative interference includes loss of community trust in traditional leadership, weakening the customary law and governance structures, fragmentation of authority, leading to poor service delivery and governance, and reduced moral and effectiveness among traditional leaders. In conclusion, while systems are in place to support traditional leadership, political and administrative interference often neutralizes their effectiveness. For traditional leaders to perform their roles meaningfully, there must be a clearly judicial boundaries. Therefore, it means the jurisdiction must be defined. Secondly, to prevent and protect political manipulation and to ensure autonomy and resources access and respect and integrate customary law, only then can traditional leaders fulfill their roles in governance and justice meaningfully and sustainable. Thank you very much.
Thank you very much. Can we please give the panelists another round of applause? Can we please give the chair of this panel session a round of applause? Thank you very much. We can now take questions. We'll start with 4. Can we have someone assisting us with mics? Okay. 1, 2, 3, 4. Yes, 4 for now, and then second round 4 again. So 1, 2, 3, 4. Yes. Yeah, 4, and then you are. Okay, so I don't want to confuse, so let's do the other 4 after this question. Okay. No, it's him. Yes, yeah. And please also remember that there are panelists that are online, so if you have questions for them, please also remember to direct a question to a specific speaker. Thank you.
Good afternoon. Igama lam ndinguNkosi uMdutshane ndiwase-Flagstaff eMampondweni. But I'm not going to ask a question, but I'm going to pose a question in the format for comment. Yeah, we are talking about the human rights here, okay, let's say gender equality. In reality, we are living one thing. I'll start with the marriage one. It's not only lobola that recognizes a woman to be the woman of that family. Kukho into ndizayibeka ngesiXhosa ke abayiboyitoli kamangesi khona nophathekile lapho uyawuzama mgebe. Akubeni intombazana kuvunyelwene ngamakhaya uba makeze azofika ekhaya. The first thing kukwamkelwa. Lento sithi ngutsiki abanye abantu xa bemchaza. But okwakwamkela kumrecognizer as a wife. Before ilobola ibe khona or after ilobola. Those are the two different things. Benifuna nje ukulungisa ukongeza lonto. Uthatha intombi yobekwe ekhaya kuthiwe ke ngoku ihendela kunyana wam ilobola ikabikho on 2 things. Akathethanga nefamily unyana into kokuba uzisa umntwana uzamzeka. Usixelela sesithi mama tata ndinomntwana endimzekileyo ndimbeke epha endlini. Kuvukwe ekseni kulaqwe kulomzi bekuthiwa ubelele kuwo. Kokwabo kuyothiwa ningayifuni intombi yenu ilapha. Now asikathethi ngokuthwala. Now sifike ke ngoku le ntombi ifika pha ekhaya kuthiwa ulele nabani phaya kulandlu nale ntombi. Remember that bavumelene. Akuvumelekanga balale nayo yedwa. Though bebethandana for some time, kodwa xa ifika pha ekhaya his brothers or cousins must sleep with him so that angaphathwa. The second aspect, kuxa intombi iye othathwa emzini kwa negotiatwa yonke into ingekazekwa isepha. But yawufika pha ekhaya kufuneka ithini yamkelwe. Sisintu eso. Yakube yamkelwe is either kuziswa ibhokhwe okanye igusha depending on how that family does indlela yayo. azokuthiwa ke ngoku intombi ungubani intombazana ungumamni azichaze athi intombi yasemathileni kwabani atsho athi umbuzo olandelayo kootata uzokwenza ntoni ekhapha hayi ndize apha ekhaya nosbanibani esithi uyandizeka uvumile ewe kuyiwe kumfana mfana laa ntombi phaya uyayizeka okanye uyizoyithini apha hayi ndiyayizeka tata kuqale kuthutywe izijoli xa sele kwamkelwe ekhaya apha azalwa khona because kufuneka kubekho ilizwe elithi ningamthatha njengonkoti kutsho ifemeli yakho kwabo then emva kokuba yenzile then ke ngoku axhelelwe ke ngoku amkelwe njengomtshakazi anikwe igama kuthiwe ngunonesi ngumarhadebe nohombile uyalithandela gama so uyazibona lezo zinto into ebangela uba ndithethe loo nto yinto yoba we constantly skip that important part yemarriage because if ayenzekanga loo nto it means akamkelwanga he cannot perform njengomfazi walamzi mandigqibele ngale nto okuthwala ke mntakwethu uxolo ukuthwala is twofold during our time when I was still young in the 1960s women were more powerful and speedy than men ndithetha ngamampondo kandazi apho kwecala lethu women were more powerful and speedy so umuntu ongumama wayekwazi ukubeka ibhakethe apha indoda ime kulaa ndawo ngeke ibambe because wavela abeka ibhakethe abaleke kodwa ubukhe wafika wambamba wathi uyamthatha eyedwa it's a waste of time because he's going to go funeka ke ngoku acela amadoda ambambise lo mntu that's where ukuthwala was misinterpreted and remember that ngexesha athwalwayo imizi emininzi ngeyingekho because amadoda amaninzi were afraid of women at that particular time bendisithi mandidlule nje apho mhlekazi ukwenzela uba nithi niyithetha ndibe ndiyithethile le yam thank you very much
Okay, thank you very much. Yeah, I'll note you. Number 2.
Thank you. I have two questions.
Sorry, can we please listen to the question?
The first question is directed to Temu Somalachi, the final year student. In your presentation, you stipulated the different types of ukutwala, and you said the other type of ukutwala, there is an agreement or consent between the two people. Now I want to understand, maybe you can expatiate, how is who's being violated when there is a consent? If the two consent, how is that a violation? Yeah, the second question is directed to Professor Fatima Osman from the University of Cape Town. I hope she's listening. With regards to customary marriage, let's say today on the 24th of September 2025, my sweetheart and I decide to get married traditionally. We get married, we observe everything traditionally, we enter into a traditional marriage. We are happy, life goes on. Then maybe in 2028, someone tells me that you need to register your marriage, your customary marriage. Then we go to Home Affairs to register the marriage. We are told that the date of our marriage would be the date when we register. not the 24th of not this day, this date. If a customary marriage is legally accepted, why is there that disparity? Thank you.
Okay, thank you, Professor Anjotini, and then behind him.
No, thank you very much, Program Director. I think we did mention yesterday, if we are to succeed in this consolidation and codification, we will need, true knowledge, because I suspect there will be a lot of rewriting that has to happen, if we are to succeed. I think for my part, I think what has been done successfully is to demonize African customary law, things African customary law. We've succeeded in that. I think, Program Director, you asked a question. It said, if it's detrimental to society, is it culture? I mean, the answer really should be no, it shouldn't. I saw colleagues were clapping. But again, if it's wrong for society, should it be religious? I'm taking this else somewhere. One of the speakers, this is for you, you can comment. One of the speakers was talking about the Ugutwala custom, which led to the discussion about people, older people bearing young girls, and most of which were HIV positive. Is that culture? It's not, isn't it? But where I grew up, there were rascals. In Lavini, you find them everywhere in society. People who operate, use a system, a working system, a reputable system to achieve their ends. I'll make another example. When a priest at the Roman Catholic Church sodomizes 11-year-olds, you don't say, let's dismantle the whole Roman Catholic Church, or even the church notion. You deal with that rascal. Is it then fair to ascribe wrongdoing to culture, as opposed to bringing up? Maybe we can ask that question also to the leaders here. Are they doing enough to curb rascals from festering in society? But is it fair to then let's stop the culture because as opposed to just dealing with the wrongdoing in the culture? For me, I think then it should be fair to ask the same question. Minister steals money, and then we just dismantle the whole process of governance and democracy, right? As opposed to dealing with that wrongdoing, that person who's doing wrongdoing. Thank you very much, Program Director.
All right, thank you.
Good afternoon or good morning. It's a pity that I should express myself in English so that everyone can hear. But it's always good to express yourself in your language so that everyone or you can able to have no limits, or all your facts can be put in a correct or right way. I'm from Gebe tribe, Nkanduli. Kumanye amaxesha ke sike sikhathazeke sizinkosi phaya ke kwela lethu. Xa umntwana egazi ebizwa ngegama likanina noyise, isivisa kabuhlungu loo nto. Ingakumbi nxa ungathwanga ke kwamekwa ubekwa isimaphambili esizawuthi inkosi ubani. Ubizwe ngathi ubizwe usana okanye umntwana. Ayisivisi kamnandi. But I must confine myself to the language that everyone understands. If the traditional leaders can give a stage in South Africa, customary law will be clear and will not hinder anyone. It's a pity that the traditional leaders, when the constitution were formulated, they were not there. Now, you cannot separate the customary law from the traditional leaders. They are the custodians of the customary law. If our constitution recognizes the customary law, as you always said that, why the traditional leaders are not empowered, are not recognized as the sole custodians of the customary law? That is the question to the presenter who was presenting the disempowerment and undermining the traditional leaders. Thank you.
Okay, thank you. Let's hear I think let's start with Professor Fatima, and then the other panelists will then take questions that were directed to them. And in the interest of time, after those answers, we'll see if there is space for one or two questions to close it. As Prof, I think that is maybe Prof Ntlama. Is it possible? Okay. Okay, I think let's see how quickly we can answer these questions. Prof Fatima? Prof, we can't hear you. Okay, let's give the platform then to the panelists in the room while Prof is dealing with the IT stuff.
Okay, so greetings again. So the first question that I got was, how is there violation if there was agreement between the parties? The first one that I was talking about, the one that I said, both parties, the bride and the groom, agree that there's going to be ukutwala. I think the chief, Unkosiwasema Pondweni, hopefully I'm saying it right, explained how that whole process is, how the girl will go sleep in the guy's family, that this is the one that's in line with the constitution and the laws of this country. So that one is the safe one. There's the second and the third one. The second one is that initially the consent of the bride was not sought. So the parents of the bride agreed with the family of the groom that they will come, take the lady, and then there's going to be marriage, which now can be also bring problems, because what if I do not want to? What about my consent? What about my rights as a person? Because I do have rights under the Constitution and all those international treaties and laws. The third one is the one that now is the most problematic, that a man can just adapt me on the road. And then that's how, and he says he's doing ukutwala. I think now, the third one now is going, I will use this third one to answer the question that Prof, our dean, asked. So the dean asks if there's always been rascals, we know that there's always gonna be loopholes, and people are going to use those loopholes anytime in the law. So the dean is asking, should we fix or should we do away with the tradition? For the third one, as things stand, I will not say, hence I said, should it be legalized or should it be criminalized? That was my question. So I think more research and more conversations needs to be had for that question to be answered. However, by how things are, if we're gonna use the Constitution, if we're gonna use the laws, the children's rights laws, the recognition of marriages, and all those other things that govern our country, the third one, and also the second type, the second type of ukutwala do not fall under that and therefore should be illegal. But also we cannot say that we do away, because saying that we do away with it now means that we are casting our cultures and customs and our traditions, which govern how we live and we interact in the day-to-day life. So my suggestion is that rather than saying let's cut off the whole thing now because of one individual, let's sit down, let's have, this goes back to the conversations that we had yesterday about codification. Let's sit down, let's have a clear rule or a clear legislature that's going to govern how ukutwala should be. How, for example, the chief explained it so well, that whole process now can be used as the steps, as the guideline of how ukutwala should be. So we are not saying that the culture must be cast away. No, we are saying reform the culture, make legislation, make sure. The Constitution says that whatever legislature must be interpreted in the way that goes with the Bill of Rights. So let's make sure that in our customs, the Bill of Rights are not in any way harmed. Thank you.
Thank you. I think the last question is, yes, the last question regarding traditional leadership.
Thank you very much. As I have indicated, that there is there's a competition and a conflict of interests between the traditional leaders and the other stakeholders. However, the reason why the traditional leaders are not empowered is because of the funding. It's because of the lack of capacity building. And in my conclusion, I indicated that the capacity building should be taken into cognizance, the funding, because the leaders, they do not have enough resources to take the leaders to trainings for empowerment. I did not capture the last part of your question that speak to inclusion. I think you were asking about that. Ngosi,
Okay.
The previous presenter said,
Okay, thank you so much. Yeah, I think, Prof. Ntlama, we are really sorry, but the questions were just too much. So let's allow, can we take two more at least? Then it means that it will have 3 questions that are being answered, because I hear that Professor Fatima also is ready to take a question. Yeah, I think the first one, let's start with Nkosi Wayne, because he's been raising his hand, and then the second one, you can just, yes, can we please also get, Prof, your guidance, Prof, can we take 3 at least? Just 2. Nkosi Wayne and Nkosi? Okay, yes, noted. 1, 2. 2 questions.
Thank you, Program Director. My question was actually to Professor Usman, which leaves a bit of a challenge, but I would have expected that all the other legal experts would be able to give some sort of guidance on the question. Because the question is, she said that you need an order from the court to dissolve a marriage. And I'm also of the opinion that this is the current state of affairs. But in our custom, the husband only needs to carry a blanket on a stick, leave it in front of the in-laws to give a message to the in-laws that the marriage failed. That is our custom. In Korah custom, that is how it happens. Yet today we are subjected to a legal system that the Roman Dutch or the Romans and the Dutch forged. And it was forced down our throats through the barrel of a gun. And yet our customary laws and customary systems existed before this law was forced down our throat. So my question is, what is our position as traditional and Khoi and San leaders? Let's put it in one blanket and say as traditional leadership who leads our traditional communities. What is our position with respect to the powers that the courts have with respect to us as traditional leaders? That was the first question. The second one was to Mr. Tlela, who stated that in his presentation that we need to accommodate and make room for customary law in our justice system. But that concerns me because that system was also, like I said, it was forced. So why should we make room for our own indigenous systems when the other system should make room for us? Or rather, we should make room for them because it's not our system. Hugo Grotius, Johannes Voet, Simon van Groenewegen, they all codified this legal system which we are now subjected to, which African indigenous communities do they come from, that they dictate how our law should be applied to our communities, yet they are not even from our communities. Thank you.
Okay, thank you so much. Last question. Let's please be brief, because where I come from, you don't interrupt Inkosi. So, but please, let's be brief so that we can get time for the panelists to respond and then also break for lunch, please.
Thank you so much, Chairperson. First of all, I would like to pose my question to Mr. Tshehla from University of Northwest. He mentioned something about males suppressing women's voices in the rural communities. And even mentioned Indo Eti, a man would say, I am a man, I have spoken, whereby there can be no opposing view from females. I'm standing here as a female traditional leader who's been in the throne for more than 20 years. I am the gender activist, a traditional leader who is the gender activist. So I'm not sure if I understood him very well or else I captured him very well on that point. I would like to have clarity on it. Then my second question would go to Umpo. Umpo has invited us to engage. I appreciated that. On your presentation, Sisi, you presented as, I can say in my judgment, your presentation was a little bit backward. It's not based on the current information about the institution of traditional leadership, in the sense that we are here as females who are leading in the traditional communities. Secondly, the legislations that are guiding the institution of traditional leadership had been fair on us, because prior I wouldn't be a leader of that community in the presence of the male figures. But now, because the legislations permits that, to an extent that every structure in the traditional leadership institution is compelled to have a minimum of 33% of women in the leadership positions of that particular structure. Women representation is a demand to be in the structure, starting from traditional councils, houses, and all the structures that are in place for traditional leadership. Youth have representatives in the councils. even people with disabilities are represented in the councils, as we have that 40% who's directly elected from the community members. That is how transformative is the institution as we are now. So in our institution, as I said, I'm a gender activist. We do not talk gender equality in traditional leadership. We talk gender justice. By gender equality, it becomes a threat to us because traditionally, we have responsibilities that are male-related and female-related. Say, the slaughtering of a cow, if we say we have to be equal to men, it would mean one day we'll have to go and grab the cattle for slaughtering. Then if we are doing our chores as women in cooking, we have our size 25, our size 30 of our black pots. It is the responsibility of young men to take those pots to the fire, from the fire for us to dish out. So that's why we don't talk gender equality, we talk gender justice. So that the capabilities that we have as women, they be recognized and utilized respectively.
Okay.
Then, the last one is to Ms. Mkhuzo. Unfortunately, yesterday, the chairperson, when he was presenting, he was disturbed by the timekeeper and he continued. So, but the last one that I'm having is for Ms. Mkhuzo. Ms. Mkhuzo, I would just like to comment on one thing, on two things in your presentation. The purpose of traditional leaders serving in the municipal councils is not to upgrade our levels, but to advise the councils on the issues that affect the traditional leadership institutions and to make sure that the things are done in a manner that is appropriate. But unfortunately, as you noted it, there is still a competition whereby they feel they are threatened by our existence as traditional leadership. Hence, we do have some challenges. Then the other thing that is a challenge in our working with municipalities, I can quote it as, it's the issue of demarcation, whereby my area of jurisdiction, that is my traditional community, would be divided into 3 wards, whereby another councillors would be on other traditional communities. And that one leads to lack of accountability because the traditional council, who is a resident to another traditional community, does not feel accountable to me, whereas he or she is supposed to service my community. I thank you.
Okay, thank you very much. So we are really strained with time. So we're going to say, with the panelists that are here, can we continue the conversations during lunch? But at least just give 2 minutes to the panelists that are online to just respond quickly to the questions that were posed, since they won't be with us during lunch. Prof. Fatima and Mr. Tshehla, I hope you noted the questions. Can I please just give you 2 minutes, please? It's both of you, please.
Yes, I won't keep you from lunch. With regards to the question about the registration date of customary law marriages, you're completely right. The date of registration should be the date that the customary law marriage was concluded, not the date you visited Home Affairs. The problem is our departments are working in silos and are not working together. So there's misinformation at Home Affairs and misapplication of the law that needs to be corrected over there. And this is the problem with government working in silos. With regards to the question about the position of South Africa's traditional leaders, when laws are so out of step with customary law practices, the answer is, it's a difficult answer, but we need to continue to hear your voices on this point until government listens. The legislation is bad. It marginalizes communities further. It further prejudices people because there's just no information about the law and it's so impractical. And so, as we push for change and as academics are making this push, we need to continue to hear traditional leaders' voices on this. Thank you.
Thank you, Mr. Tshehla. One liner in
Yeah.
responding to that question.
I think it's a question of probably not being there or miscommunicating. The speakers, in fact, agree. I agree with them completely. Just in short, the issue about the system that we have accommodating traditional leadership. In fact, that is the very point that I'm making. That we are pushed in a corner where our system is being made to find room and be accommodated, and that is not the right way to do it. I think I had hoped I made that point. So in short, I agree, and I won't belabor that point. It's just unfair that we are trying to cave a space for the customary law because it should be sitting where it deserves to be without someone having to accommodate it. So I agree completely, and I'm glad you raised that. If the impression is that I was saying I support the move, I don't actually. I could talk the whole day about that, but let me stop there.
All
And
right,
on the question, the second one about the issue of an example of in a traditional court, a woman speaking or a female speaking after a male. I think that the issue there is broader than the example I gave. I gave an example, and I was not saying it generally applies everywhere. I've said in many of those, so I'm not, as an observer, and it doesn't happen everywhere. But I used that example that unique as it may be, it points to a bigger problem, which is this. You take or you go, and I'll use gender equality. I agree completely that the right word is gender justice. That is the right approach. But I'm going to use gender equality because that is the language that the statutes use. I'm saying you don't say we put 33% of female in there and then you leave the systems as they are. There's got to be ways in which you make their stay in there reflective of where you are going. In short, I agree with both speakers, and I apologize if I said the opposite of what I intended. I definitely don't believe customary law should be accommodated. Thank you. I'll leave it at that.
Okay, thank you very much. I'm going to call Dr. Ntando as we clap for the panelists and the chair. Thank you.
Please click our panelists. They are women, after all. I do specialize in the rights of women and children in my other life. So when I see women, I always say that what the boy child can do, the girl child can even do it better. And I think we see it. Thank you so much. I'm not going to waste your time. And program director, with all the protocols in the morning, please, with all due respect, bear with us. We are pressed for time, so we can continue the conversations upstairs during lunch. We respect you so much. We're getting wisdom for our students, and we're going to produce knowledge informed really by the rich knowledge that you carry. So I'm going to ask that we allow our visitors and our traditional leaders and our judges to exit here and go upstairs. Lunch is ready for us, and they need to be followed by us at the back. So I will allow that you exit just by this door. You go upstairs. So our lunch is now reduced from 1 hour to 55 minutes. Thank you so much. Bon appetit. Ningaphuma nje ngalo mnyango. No.
Oh, okay. Before I can proceed, I would like to introduce myself. My name is Asanda Mbulambi. I'm one of the lecturers in the Faculty of Law here at University of Fort Hare. All right. And apparently this is the last session of the day, and the theme of our session is customary law in legal education. I would like to call upon all the panel members to come forward. And the first one, if he or she is here, please make your way to the front. Advocate Stefan Nyarango, and he's from the University of School of Law in Kenya. It seems as if he or she is not here. And our second panel member is Advocate Pategile Olomisa, Inkosi of Amahegebe. Thank you so much. And Controlesa, Honorary President. Let's give him a round of applause. No, you can take a seat for now. Okay. Thank you so much, Advocate. And the second speaker is Bonagali Sotele. He's from the University of Fort Hare. And could you please come forward? Bonagali Sotele. Make your way to the front. Let's give him a round of applause. And I've been notified that the fourth speaker is not, he or she could not be here with us today due to an emergency. Let me jump straight and go to speaker number 5. Tulumango, Yangis, and Ms. Astal. They are both from the University of Fort Hare. Let's give them a round of applause. Thank you so much. That was Mrs. Thelma. She's multi-talented, as you can see, and she's also the member of the faculty, officially known as the Diva. Let's give her another round of applause. All right, moving right along with our program, I would like to call the last speaker on the program to come forward and join the panel members. Her name is Ms. Giabetswe Masejo Mahoko. She's from the University of Northwest. Okay, it seems as if she's not here. Let me consult with my timekeeper. All right, this is what we have agreed upon. Since we only have 3 panel members, we have decided that each speaker will be allocated 15 minutes instead of 10 minutes. I think that is fair enough to everyone, okay? Now I'd like to call Advocate Patekile Holomisa to come forward. He'll be unpacking a very interesting topic titled Customary Law and Legal Education, creating space for the regulation of constitutionalized system of traditional governance in South Africa. Let's give him a round of applause. Over to you. Thank you.
Molweni. Ndibonile into bana nimvile umama uThelma nonke apha ugqiba kwakhe uthetha. Into ethetha ukuthi ndibone niqhwaba. Into ethetha ukuthi ke niyas-understand isiXhosa ngoba bethetha isiXhosa. Yes, since we have all applauded the message by Ms. Thelma when she was concluding her remarks here, I take it you all understand Xhosa, so I don't have to be twisting my tongue, trying to accommodate a minority in any event. Yeah, so much has been said about what has been done by our colonizers to our ways of life. There's no need to be making the point once again, but maybe it needs to be made until the damage has been undone. Here, we as Africans here, those who are natives and those who are from other countries. I heard there are people from Namibia and also from Kenya, and I think the assistant deputy vice chancellor, acting deputy vice chancellor is also from Nigeria. He told me when we were speaking here that he is a Catholic by birth, after having told me that he's Igbo. Igbo is one of the tribes or nations, if you like, in Nigeria. But when the first thing that comes to his mind when he speaks about his identity is that he's Catholic. That yo, ingxaki inkulu. Now we are trying to find a way of getting recognition in a democratic South Africa, a supposedly free South Africa, of customary law within a legal system that came after the original system of law was already in place. And so they managed to overwhelm and undermine our ways of life to the extent that we are just continuing it by ourselves. They don't have to lift a finger. They don't have to tell us what to do. We just do it automatically. Because when this country was stolen from us, it was under the leadership of the country's kings and queens and other traditional leaders. There was a system of governance. And that system of governance was based on African law, which we have had to call it customary law, so that we don't put too much emphasis on this correct identity, which is African, so that we don't offend people who are keen on denuding us of our true identity. Now, it's a difficult topic. Nkosazana did say that is a complicated topic. I tried to rack my mind to write something about it, and I simply couldn't come up with anything. I decided that I'll allow the spirit of my ancestors to guide me on what I have to say regarding the opportunity that has been given to me here. But let me try and let me try and say something. See, it's difficult because I've been. It's difficult to understand why I'm struggling to say something about this, because for almost 23 years of my adult life, I've been talking about the role of traditional leadership in a democratic South Africa. I even produced 2 books out of the statements that I had been making to try and justify why the institution of traditional leadership and all that it stands for must exist in a democratic South Africa. Because South Africa, being a democracy, having achieved freedom, it had adopted a new system. It had adopted a constitutional order that is based on the will of the people, because the people have elected our lawmakers through a political system that is fashioned along the lines of those of our oppressors. So we had to struggle, especially as Contralesa, but as traditional leadership in general, to ask for accommodation in the new order. In fact, it's an abnormality that the original owners of the land, rulers of the land, even if their descendants, now have to request that they be accommodated. When there's a war or a hunting expedition that is being undertaken, it is directed by the king of that particular community, and young men, young and able-bodied young men, go on that expedition, on that hunting expedition. When they come back with the animals, they bring them to the great place, the royal residence. Then the traditional leader and the elders dish out some of the spoils to the various families that were represented in that expedition. Now, what happened here, our traditional leaders led the wars of resistance for something like 100 years, as recorded by our oppressors, and also 49 wars during that period, resisting the invasion of the land. And then the number of battles that cannot be enumerated were fought in this particular part of this country, South Africa. And now, later on, as they were fighting the invaders, they were defeated because they had superior arms. They were trained in the art of killing people in a manner that were not able to resist and repel. So Later on, an organization was formed, the African National Congress, in order to prosecute the struggle further under different conditions. Now, what was expected was that when that war was won, then they should report to the kings of the land that we are here, we came back successful, and this is the position, what is to be done, so that they are told by the kings that this is what needs to be done, now that our land has been brought back. Now they forgot that, so they dismissed it, even if they were aware that the true descendants of those people are still alive. So when CODESA was convened, all the political parties of the time, even the right-wingers, the racists, in those formations, they were invited, they were pleaded with, or Terre Blanche and Abanye were being pleaded with by the ANC and the National Party and others to come to the negotiating table. The traditional leaders were denied entry and participation until there were threats of violence and other kinds of things to what was happening at the time from some of the other formations that were supportive of the institution of traditional leadership, and then in fear of the violence that was likely to take place, because violence was already taking place anyway. So they decided to invite Consolidation and other traditional leaders to come and represent the 4 provinces at the time. This being the Transvaal, the Natal Free State, Orange Free State, and the Cape Province. So that's when we came. As a result of our limited and belated participation in those negotiations, the constitution that was formed, what was called interim constitution, contained provisions that gave somewhat of meaningful recognition of the institution, where we're expected to participate in all 3 levels of governance as traditional leaders, and participating fully in local government and so on. But when the final constitution was crafted, those principles that obliged a future government to give recognition and protection to the institution of traditional leadership were cast away. The other one was actually watered down. Instead of recognizing and protecting the institution of traditional leadership as the constitutions dictated for the new constitution to be legitimate and legal, they removed the word protect and wrote recognize. We objected to the Constitutional Court as was required in terms of the law of anyone who was displeased with the outcome of the Constitutional Assembly work. Now, the eminent judges, I think all of them understood English. They said the word recognize meant the same thing as protect. So it's not really important that the word protect is not in this new constitution, because it means you are protected. How can you be recognized? Gandhi, you are not protected. Of course, we know that that was false. In fact, some of the judges, I used to be close with them as I was serving as a lawyer at the time. Through Natal, they told me in confidence, laughing, that, we're worried about this thing. Well, we just decided that, no, let's just say, if you are recognized, you are protected, so therefore, there's no problem about that. Protecting would have meant that we were part and parcel of the constitution-making processes in the Constitutional Assembly. But that would have happened through the establishment of the House of Traditional Leaders. It was called the Council of Traditional Leaders at the time. So that we can continue to give our own contribution in terms of the perspective of African customary law and the ways of life. But they delayed the establishment of the house until the constitution was adopted in 1996. That's when the National House was formed. So we were denied the opportunity, therefore, and the right to participate in the crafting of a final constitution. As a result, we are today here talking about how do we accommodate the customary law, how do we find a way of getting it taught or getting our people to be educated about the customary and legal system of governance. Now the problem is that we leave this institution. I'm happy there are so many traditional leaders, and also there are women traditional leaders here, because quite often we are presented or painted as people who are backward, who are oppressive of women. There's a term now which is in vogue called patriarchy or patriarchal. I thought the patriarch meant something like a father, just as matriarch meaning something like a mother. So if now you are a father, it's a crime because you are patriarchal, which means you oppress women as a matter of course. And yet these are the people who live with us, the women and children, when men are going to work for the white man in the farms, in the factories, and in the mines. We are their first port of call when there are problems within their families. We look after them. We call upon the men, especially when they come back, to tell them that they are failing in their duties to maintain their children. Imali abayithobi bayitya nabanye abafazi ababafumana phaya elento eGauteng. Now, there are so many things that we do as traditional leaders. You doing our work to protect the weak and the vulnerable. There are so many things that are happening now because we are not empowered to enforce discipline in the way that is demanded by our laws as Africans. There's no respect for authority. Nobody fears anyone in terms of doing whatever they want to do. The breaking of the law is rampant. There's now these drugs that are so readily available. No one is there to protect them. I mean, to prevent the scourge continuing to take place. So I would say, therefore, it would be helpful if, as academics and people who have funds to support research work, to spend some time in the countryside, to visit our villages, to attend the sittings of our courts as traditional leaders, instead of having to read about us in papers that have not even been written by our own people. Even those that are written by our own people are people who are distant from the reality of the life that we lead under customary law. People fortunate or unfortunate enough to be living in the cities who do not understand what is happening there. So the justice that is there, I'm happy Nkosi Nokaka Ujumba gave a proper term to what should be said about the oppression of women and abuse of women and children, that we should be talking about gender justice, not gender equality, because that is problematic. I don't even think a number of women would like to be equal to men because of so many factors that are there. Someone said, one of the young ladies said, women, when they are empowered, they are better at building their homesteads and their families, providing first for their families before they provide for non-members of their families. So I am saying therefore that if you were to be able to go and study there and live there for some time, not just for a week, understand what is happening, you would know. In fact, I'm asking the question myself all the time. If traditional leaders are allowed to do their work, provide safety and security to their members of their communities, provide the services that are needed. 20 minutes? Oh, sorry. Who loses? Who loses if traditional leaders do their work? They make sure that those who violate rights of women and girls are brought to book in terms of our ways of life. Who suffers because of that? The only conclusion is that people are envious of the power, authority, and respect that we have as traditional leaders from our people. They would rather, if only they could have that power to themselves. It would be so nice to be a politician, but we don't have the law supporting us. Yet the influence that we have is such that they come to us when their programs are unimplementable because of corruption and all sorts of other negative things like incompetence. They come to us and we ask ourselves, why do you want to come to us when you have all the power, you have all the mandate? They say they have the mandate of the people. You are unelected leaders who don't have anybody's mandate. But we are comfortable, Tina, that we know that we got our mandate from our ancestors. Whenever you want to do something, you want to ask yourself, what will my grandfathers or grandmothers say about the kind of action that we are going to take? We just can't imagine ourselves offending those people who gave us our mandate. So, kunzima ke uyithetha lento ukuchaza ba kumele ba kuthweni na kufundiswa kanjani. Izolo oku, the reason we were not able to be here yesterday is because our traditional council was sitting and I'm presiding over it as the leader of the tribe. And so much was happening there. I wish that some of the academics and other people interested could come and sit and listen, because that system is inclusive. Everybody is entitled to have their say, even when we are trying a case. That system is meant to ensure that we are fair to everyone, whether it's a woman or a man, a young person or what. We use a language that everybody understands. We don't need interpreters. Unlike what happens in courts, where you'll find a black judge, Manditi, a Xhosa-speaking judge, or magistrate presiding. There's an interpreter who is Xhosa-speaking. There's a prosecutor, Xhosa-speaking. There's a policeman keeping order, is Xhosa-speaking, and everybody is Xhosa-speaking. The litigants are Xhosa-speaking, and yet, bayakuthetha isingisi basiyophulwa nesingisi ngoba lokhu ayisosethu. Kodwa xa abantu bethetha ngesiXhosa iyalahleka the meaning of what a person was saying in translation, because this is all artificial, it's not natural. So andazi ke noba ndizamele uyiphendula into benengicela uba ndiyenze. Enkosi kakhulu.
Oh, okay. Let's give Advocate Patekile Holomisa another round of applause. And we'll all remember that right from the onset, when he started his presentation, he indicated that he will allow his spirit, the spirit of his ancestors, to guide him. And indeed, Advocate, you did exactly that. And I would like to highlight the fact that thank you for the thought-provoking topic. The key takeaways from your presentation that I've noted, one was that you gave an extensive history and you informed us how the CODESA was informed. But what was important was the fact that you mentioned that the key role that the traditional leaders play is that they protect the vulnerable, despite the challenges that they come across with. But what is important is that in order for you as traditional leaders to perform your duties effectively, you need to be provided with all the tools of trade. Thank you so much, Advocate Patekile Wolumisa, for that. Now let me call upon the second speaker to come forward. That is Sibonagaliso Cele. And as he make his way forward, his topic, the topic that he will be covering is titled Balancing Tradition and Equality, Enhancing Women's Rights in Customary Law. Now let me mention this. He is currently doing his third year and he is in my class. Over to you.
Good afternoon, everyone. I hope you are all doing well. And I would like to say Happy Heritage Day to you all. I appear in front of you to present my topic, which is balancing tradition and equality, enhancing women's rights in customary marriages. I'm Sibonagaliso Cele and I come from Port Shepstone, KwaZulu-Natal. I grew up in a place where tradition is everything, where elders speak and we listen, where marriage is sacred but not always fair. I have seen women in my community give everything to their families, yet walk away with nothing when things fall apart. Now, as a third-year LLB student at the University of Hote, I carry those stories with me into my studies. So one of my academic advisors, who is Miss Siron Stahl, helped me see that law can be a tool for healing. I have participated in moot court competitions, argued cases, and learned from every moment. But this topic is very personal because I believe that tradition should protect, not punish, and I want to be part of the change. So as a person who usually suffers from a low self-esteem, Ms. Sironstahl once said to me, keep working hard, keep pushing forward, and keep believing in yourself. Your strength and resilience will take you far. You were born for great things. Remember, potential and determination can lead to great achievements. So appearing in front of you, I take it as an iconic thing. I feel like I'm a star. The reason why I chose this topic is because I come from a place where weddings are more than just ceremonies. They are just songs, dances, elders' blessings, and long-standing customs. But behind the joy, I have seen quiet pain from women who give everything, yet are left with nothing when the marriage ends. In our villages, tradition is sacred, but sometimes it forgets the voices of women. This topic matters to me because it is not just a theory, but it is a real life. It's about our mothers, sisters, and daughters. I chose this topic because I believe tradition should protect, not punish, and I believe law can help us remember the dignity we owe each other. In the past, tradition was only law many families knew, but today we have a constitution that speaks for those who were once unheard. Section 9 of the Constitution of the Republic of South Africa says, everyone is equal before the law and has the right to equal protection and benefits of the law. This means that women in customary marriages must be treated the same as men, meaning no more and no less. Section 10 says, everyone has inherent dignity and the right to have their dignity respected and protected. Even in marriage, dignity must never be lost. Going to the Recognition of Customary Marriages Act, which was a turning point because it gave legal recognition to customary marriages, protected spouses, and required registration. It also made sure that women could claim rights to property and maintenance. With reference to the case of Bear versus Magistrate Court of Khayelitsha, the court said that male-only inheritance under customary law was unconstitutional. This case reminded us that tradition must walk hand in hand with justice. Other cases like Shilubana versus Namitwa showed that customary law can evolve. In that case, a woman was allowed to become a traditional leader, something that was once forbidden. The law is not here to erase our customs, but it is here to make sure those customs do not erase our humanity. So, can tradition and equality coexist? Tradition is the soil we grow from. It holds our stories, our songs, our ceremonies. But even the richest soil must be turned over sometimes so that new life can grow. Customary law is part of our identity because it teaches respect, unity, and belonging. But when it forgets the rights of women, it becomes a shadow of what it was meant to be. The Constitution does not ask us to abandon our culture. It asks us to make it kinder, fairer, and more just. In the case of Maelane versus Ngwenyama, the court ruled that a husband must get a consent from his first wife before marrying another woman under customary law. So we can look at Isitembu of Mr. Mselegu from Mzumbe. This case showed that even within tradition, women's voice must be heard. We can protect our heritage and still give women a voice. We can honor our ancestors and still uplift our daughters. Tradition and equality are not enemies, but they are just two hands that can build a better future if we let them. To improve, how can we improve the fairness in customary marriages? Change doesn't mean forgetting who we are, but it means remembering who we have left behind. To make customary marriages fair, we must start with simple but powerful changes, which is letting women co-own property with their spouses, give both partners an equal voice in family decisions, and ensure divorce laws protect women from being left out with nothing. These changes do not erase tradition, but they restore its dignity. The Constitution gives us tools, and the Recognition of Customary Marriages Act gives us the framework. Now we need the will to make it real in our communities. When women are When women are treated as equals, families grow stronger and tradition becomes a place of healing, not hate. We are not alone in this journey. Other African countries have walked this path, and we can learn from them. In Uganda, reforms in customary law have helped women gain land and rights. In Ghana, traditional leaders were trained to understand constitutional values. And in Kenya, courts have ruled in favor of women's rights in polygamous marriages. These examples show that culture can evolve without losing its soul. South Africa has the legal tools. What we need is community support, education, and leadership. If others can do it, so can we, because our traditions are not broken, but they are just waiting to be renewed. Laws can be written in books, but real change is written in our hearts. We can pass the best legislation, but if our communities don't understand it, it becomes just another forgotten rule. That's why education is the key. We must teach women their rights and teach men to respect them. Traditional leaders must be part of this journey because they are the voices our people trust. If they speak for equality, others will listen. Let's hold community dialogues. Let's bring the Constitution to the crowd and let the law speak in the language of the people, because when minds change, customs follow. So looking at the bigger picture, this is not just about the law. It is about the healing of generations of silence. When women are treated fairly, families become stronger. Children grow up seeing respect, not fear. Customary law can be a tool for justice if we let it grow. We are not trying to destroy tradition, but we are trying to restore its soul. A soul that remembers that women are not just property. They are partners, they are leaders, and they are the future. Let us build a South Africa where tradition and equality walk side by side, not in conflict, but in harmony. Conclusively, in balancing tradition and equality, we are the children of tradition, but also the voices of change. Customary law is not the enemy, but it is a mirror of our past. And with care, it can reflect a better future. We don't need to choose between culture and justice, but we can have both. Let us build a South Africa where women are not just part of the story because they are the authors of it. Let tradition be a home, not a cage. Thank you so much for taking this journey with me.
Women are not just property. That is why today I am here as your MC for this session, because we are not. Oh, okay. Thank you so much, Sibonakali. So, two things stood out for me from his presentation. In order to balance the tradition and equality, he mentioned two cases, and the leading case of Bear. And he indicated that from those cases, what is important is that as much as we have customary law, at the end of the day, it must evolve. It must evolve. And also on the issue of whether tradition and equality, they can coexist. The conclusion regarding that one was that the two are not enemies. And what was also interesting about his presentation is that he went an extra mile. by also doing a comparative analysis so that some of the lessons can be drawn from those countries such as Ghana. Let's give him another round of applause. And now again, and also even this one, she's also special. She's currently doing her final year LLB degree, and she's also in the faculty. And her name is Tulumango Yankis. And the topic that she'll be discussing or unpacking is titled Reconciling Tradition with Constitutionalism, Evaluating Gender Equality Reforms in African Customary Law through the lens of Bear versus Magistrate Kayelicha. Over to you.
Thank you very much. My name is Tulumango Yankis. I'm a final year LLB student from University of Fort Hare. I'm also a proud peer facilitator at Teaching and Learning Center. Greetings to the House at large. It is such an honor to be here and standing in front of everyone, as I am planning to further my studies and do my master's next year based on African customary law. I am highly captured by the idea of gender justice, as I am someone who is captured by the idea of relational feminism, which affirms gender differences. It accepts that women and men have distinct traits, role, and social contribution, but it does not see these differences as grounds for inequality. My topic for today is reconciling tradition with constitutionalism, gender equality reform in African customary law through the lens of Bear versus Magistrate Kayelicha case. South African constitutional democracy is often celebrated for its progressive Bill of Rights, yet nearly 3 decades later, the tension between constitutional guarantees of equality and the lived reality of customary practices remains unresolved. My paper explores this tension, focusing particularly on gender inequality in African customary law through the landmark case of Bear versus Magistrate Kayelicha. African customary law is constitutionally recognized in Section 211, subsection 3. It forms part of the legal system and must be applied by courts when it is applicable. However, it is also subject to Bill of Rights, which requires that customs align with principles and equality and dignity. This constitutional recognition creates a paradox. On one hand, the law seeks to preserve culture. On the other hand, it demands transformation where culture perpetuates discrimination. Several customary practices remain deeply patriarchal. This includes ukutwala, historically a marriage practice, but today often results in child adoption and sexual abuse. Virginity testing, partially legalized under Children Act, but widely criticized for undermining dignity and privacy. Widow rituals such as ukungena, surrogate, and levirate unions, practices that subordinate women by treating them as inheritable or replaceable. And also lobola, while culturally significant, it has been challenged. There is a link to perception of women as property. Most significantly, the rule of male primogeniture excluded women and children born outside marriage from inheritance. In the case of Bear versus Magistrate Kayelicha, the Constitutional Court was asked to decide whether the male primogeniture rule and Section 23 of Black Administration Act were constitutional. The court declared both invalid. It was the system of male primogeniture unfairly discriminated on the grounds of gender and birth. The Interstate Succession Act was imported to govern African customary succession until Parliament enacted new legislation. This judgment was heuristic It secured inheritance rights for women and extramarital children, making a decisive step towards substantive equality. However, it also revealed that the judiciary struggle, the majority chose to abolish the rule outright rather than develop it, while Justice Ngobo in dissent argued that it could be created by removing its gender biases. This debate reflects the broader difficulty by balancing constitutional values with the integrity of customary law. Despite cases such as Bear, Shibi versus Sitole, and Mtembu versus Litzela, reforms have been piecemeal and inconsistent. The court have sometimes prioritized equality and on the other times deferred to culture. Legislative interventions such as the reform of customary law of Subsection Act have helped but also revealed gaps. The key challenge lies in the dual recognition of official customary law, often codified during colonial and apartheid rule, and living customary law, which reflects the evolving practices of communities. Courts have not yet applied this distinction consistently, leading to uncertainty and fragment of jurisprudence. Moving forward, in customary law, if customary law is to remain in a meaningful part of South African legal system, its development must be principled and transformative. Courts and lawmakers must treat customary law as a dynamic, not frozen in colonial codifications. Prioritize the lived experiences of communities, particularly women. Ensure that reform do not erase culture, but reshape it with constitutional values. Ubuntu reminds us that the law should advance individual dignity and communal harmony. Reconciling tradition with constitutionalism requires balancing these values rather than choosing one at the expenses of the other. Lastly, the case marked a watershed. The Bear case marked a watershed in aligning customary law with constitutional equality, yet more than 20 years later, challenges persist. Without a coherent framework for reform, women remain vulnerable to cultural practices that undermine their rights. As scholars, practitioners, policymakers, the task before us is to ensure that African customary law evolves in a way that preserves culture while affirming gender equality. Only then will the Constitution promise a dignity and equality for all truly be realized. Thank you very much.
Okay, thank you, Kulumango, for such thought-provoking presentation. Let's give her again another round of applause. A few takeaways are from her presentation. You mentioned that the tension between tradition and the Constitution, they remain. And she also made reference to the case of Bear, which was also discussed by Usi Bonagaliso, and pointed out that as much as the reforms have been done, but that has been done on piecemeal basis. Okay, that was our last speaker for our session. Now, this is what I'm going to do. I'm going to open a round of questions, okay? I would like to plead with our audience that please, when you ask your question, keep it short and make sure that you ask only one question so that you can also give other colleagues a chance to ask a question. So this is how we are going to roll now. From this side, I'm going to take 3 questions, and then from this side again, I'm going to take 3 questions. Make sure that when you ask a question, you direct it to one of the presenters to say this is directed to Advocate Pategile Olomisa or to Tulumango or to Usibona Galis. 3 questions from this side and then 3 questions from this side. That will be round number 1. And then I'll also take another 3 questions from this side. So we'll continue in that manner. Let me start from this side. 1, 2. Oh, okay. 3.
Manbulise wakhona luthethayo ngugama wesisithethisi sigqibo kuhlala phansi ukhuluma ngco kaSigcawu. The question I have is for all 3 panelists, unfortunately, and I apologize for that. The question I have is that are we in this room interpreting our customs correctly? And I ask that question because there's a lot of play about equality, whereas where I come from, the wife is known as Inkosikazi, and then the husband is known as Inkosiyam. That's how Amampondo would refer to each other back in the days. Leomi and Into Incha. So are we actually interpreting our customs in the correct way? Because this is day 2, and I'm noting that more than actually trying to present what our customs and cultures are actually about, we have been bashing our customs, bashing our cultures, so that they can find space within the Constitution. And a number of speakers have been expressing that the Constitution is a new thing. So why is it that we want to find space for our customs in a new Constitution that has not evolved since 1996? Yes, yet our customs are being demanded to evolve and develop with the times. Thank you.
Enkosi kakhulu. Mine would be with Tatu Advocate, Kusiphathekile. In the eve of the constitutional development of the Democratic Republic of South Africa, you're telling us that you are absent as Inkosi, as the House of Traditional Leaders, because the House was not yet formed. Now it gives us a problem when we are going to try and interpret what does the customary law mean in the post-colonial South Africa, and also to understand it in terms of pedagogy as an ongoing process of educating our kids. Knowing very well that the African way of life and depends on the oral transmission, not on the documentation. And there is a breakaway of family line towards the upbringing yomntana in order to orally transmit the values, customarily values and rituals and everything. Now, I would concur with you, Mr. Staw here, I don't see anything wrong with our way of life and how customary law has been interpreted by the Western other, because it must be interpreted as an African way of life from the Africans, not through the lenses of the West. Because we are going to interpret, we are going to have a juxtapose between a Western phenomenon and an African phenomenon. And that's exactly what we do not want to go through. The West must understand the Africanity and must understand the Africanness and must understand the African customary law from the African lens. Not because it was written by another person who came and listened. A village was umamela amaxhego xa echaza ehlele enkundleni echaza indlela abaxoxa ngayo icases zakwaXhosa. But from an African perspective, from the people that know how to live and how to discipline a child. In another symposium that we had in the faculty, I was asking the same question, that we should not be juxtaposing our way of life into the Western other, because the Western other have their own culture within their own epistemologies, within their own laws. So we need to look at our way of life and interpret and document before history write us off. Thank you very much.
Okay, thank you. Mine is very brief for Advocate Phathekile. I just wanted to understand from an outside position some of the conflicts that you've had with having 2 structures, and which, of course, for me, I think the other one, which are councillors, have sort of usurped the functions that the chiefs have to do. Just wanted to understand some of the conflicts that you have come across with the councillors or politicians, as we call them, and whether, in your view, you think these two structures can coexist. Thank you.
Uthi njengomuntu omdala mawuqale mina. Yes, I agree with the second speaker. Unfortunately, I didn't get her name. Also because I was not here yesterday when introductions were made. I agree with her when she says that in view of the fact that traditional leaders were not participating in the constitution-making process and in terms of the Constitutional Assembly, that gives us a problem because obviously the input, valuable input that they would have made was lost. Because as I said, the final constitution destroyed the institution of traditional leadership. It removed them from decision-making bodies in all spheres of governance, in the sense that while they could participate in local government activities under the interim constitution, they were not allowed to do so in the final constitution, even when a limited number of seats was accorded to traditional leaders in the local councils. They didn't have any meaningful role to play. They were just there as observers. People were just giving dignity to the structures, to the municipal council as they were sitting there. They were not even given any of the resources that were given to the elected politicians who are councillors. So even at the other levels, the houses of traditional leaders that are there, they are meant to advise the president or the government when he feels like seeking out their advices. It's not automatic that they should go and advise the president. If they want to advise them, they have to plead with the president so that they can come and talk to them. And if you follow what has been happening since the house was established, especially the national one, every year they say this needs to be done, this needs to be done. They never give responses to the questions that are raised by the members of the house. I also agree that if we follow our customary practices properly, they are not meant to bring harm to anyone. That system is there, among other things, to protect the weak and the vulnerable, most of whom are the women and children. So it would be an anomaly when we were to find that harm is brought to these people on account of it being said to be demanded by culture, because culture doesn't demand that anyone must be harmed. It's there to protect. And well, again, I agree when you say the West must understand our customs from our own perspective as Africans, because they also have their own customs and cultural practices. Nobody is questioning them. They do all sorts of things that are funny, in our view, introducing some of them into our systems of life, and we don't bother them. But unfortunately, they imposed themselves on us when they came here, and they continued even when they remained here. Even after democracy, they still oppress us. Now, indirectly, we swallowed it, we've been captured, so we just do it automatically without anyone telling us to do it. We just look behind our backs, to see are they going to be pleased with what we're doing, because it seems as if it's not in line with their own culture. So the harm, we're doing it to ourselves, and we are in power, I suppose. So we should be addressing these issues. Councillors are not really on their own usurping the roles of traditional leaders. That's given to them by the Constitution and the laws. And therefore, what can they do if they are given the power? And as everybody knows, if you are given power, you don't just give it away easily. And because now they are perceived, even by the president, unfortunately, that they are not using the powers they have correctly, which means then that something must be done about it. A number of people are calling on traditional leaders to take up their responsibilities and lead the country. But we are conscious of the fact that it's a democratic order that we live under. People must also have a say in the election of people who are going to make policies and laws that will be affecting and governing their lives. Traditional leaders, through their structures like traditional councils and so on, are local government in the true sense of the word. Even during apartheid, resources or services that were provided to rural communities were channeled through these traditional councils. And there were no serious complaints about corruption and so on. But of course, corruption is a human thing, generally. But the outcry was not as much as we hear about it now, about traditional leaders abusing money that is meant for the people, especially the vulnerable. So, but they can coexist as long as they respect the fact that traditional leaders in the first place are the primary, practically primary level of local government, because they control the land. And there's no way that you can imagine the control of the land being usurped from traditional leaders, because it will be like taking King Ginza's land and giving it to somebody else, or King Tsajoyo and all the other kings in the country. Yeah, thank you.
I'm not sure if I got the question, but I think that after the Constitution became into action in 1996, in customary marriages, the rules that are outlined in the Constitution are still not being followed. So where I come from, in customary marriages, women are not treated fairly, but they are treated unfairly. So making an example about my uncle. So my uncle in my family, he got married under customary law last year, but he just came with the rules that his wife will not work but stay in home. I feel like his wife is just an object, because I think her rights are not being followed. So according to Section 9 of the Constitution, as I have said, it says everyone is equal before the law and has the right to equal protection and benefits of the law. I feel like in some marriages, women are not being respected, but men want to be respected. I'm not sure if I'm answering the question correctly.
Ndicinga into ethi ukuze mhlawumbi icace le nto mandiyithethe ngesiXhosa. Okokuqala siphila kwilizwe ledemokhrasi. Kulo mcimbi ke weenkosi ndiba nengxaki yento kokubana kuba kusithwa umuntu ngenxa yoba engumntu anegazi so uyangena nje kwesasikhundla sobukhosi. Now ihamba ke ngoku indinike ingxaki kwinto ethi nezinto azenzayo akadluli mntwini. Into ayenzayo inkosana zakhe uyazonyula ngokwakhe without consultation nabantu. And ndicinga into bana abona bantu bakhipha into yolonyulo lwenkosana ngaba bantu bahlala nalo mntu kuba kufuneka beyazile oyena mntu banokumonyula abamaziyo indlela abaphatha ngayo abantu ekuhlaleni indlela athetha ngayo nabantu ekuhlaleni indlela enza ngayo. But this time sifumanisa into ethi kunyulwa nje inkosana akubuzwa mntwini inidwarule kuloo lali niphathe ngendlela engeyiyo. Okwesibini ndinengxaki yento kokubana kwalapha kwinto ye-traditional leaders kuyenzeka into kokubana kubekho into let's say itower ezizo Vodacom no MTN ufumanisa into kokubana imali yayo ayiyi kwaba bantu bakulo mhlaba lo ilanto ipali ikuwo. Into kunayo ithunyelwa straight enkosini, inkosi yenza ukuthanda kwayo ngaloo mali ingaze ibanike abantu.
Enkosi tata, ndicinga uba tata awuthongo uqala uba uphuma kwesiphingo Nkosi uNdlazi lona from Hilltown. Ndifuna ukucacisela ke mhlawumbi ngale language ubuthetha ngayo ukwenzela uba sizovana. Silawula ngokomthetho ne umthetho lo wokuqeshwa kwenkosana allows ukuthi i-royal family ibe yiyo enyula inkosana. Zithi ke ngoku xa i-royal family ingenayo inkosana for loo lali, ndiza kwenzela umzekelo ngampha esizweni eNxukhwebe ndineenkosana ziyi-7 azizo zasekhaya zenyulwa ngamalungu elali. Kwi-case whereby unikwa inkosana okanye isibonda, inkosana mandibeke ngolo hlobo, kulapho ingumntanekazi from the family. Then if akaphumi apha kulo mnombo wasekhaya ndiya kwi-community ibe yiyo ezondinika umuntu ozobambela umntanekazi ayiyo yakhe loo ndawo. So the department iye ibuye izomtshekisha. Coming kwinto ye-polls ezisemihlabeni yenkosi, ndifuna ulungisa le nto ithi kuqala kulalali awunamhlaba uyilali. Umzekelo ndinelali ndirulisha ilali eziyi-17. If ndine-poll eNxukhwebe which is kwalamyeni apho ndikhoyo, laa mali yalaa poll ayisiyo yabantu baseNxukhwebe kwalamyeni, is for the 17 villages endizikhokheleyo. Xa kune-program ezokwenziwa ndibiza inkosana okanye the community ihlale phantsi kwisicelo selali nganye, but ndiqala uconsiderisha ngaline poll if aninanto niza nayo ngaphambili, then ndizawuyithatha imali ndoyisebenzisa kwenye ilali. Ngethamsanqa ziya-audithwa iingxowa zakomkhulu. So ndifuna uyibalekisa kuwe mhlekazi le ngqondo nayo. Mhlawumbi uye abantu abaninzi kabaye ezimithingini umuntu ahlala ekoneni avela justify into yoba laa mali ityiwa zinkosi. No, asiyityi imali yabantu, yimali yabantu leyana, abantu abathatha ii-decisions. Ndibe newari ke izolo kuthethwa apha qha ndabe ndiphuma ndiphazanyiswa yifowuni. Sesiyibhala le mithetho siba nazo ii-bylaws. Bendifuna udibana nawo ntombazana encinci. Sinazo ii-bylaws ngokwengingqi umzekelo phaa kuMail Town indlela esixoxa ngawo amatyala yindlela equlunqwe ngabahlali bonke baseHill Town siyazibhala thina phantsi ukuthi sifuna uhlalisana njani as community yaseHill Town. So la bylaws sibe nethamsanqa into yoba siyazisa kwamanye bazisayine. If kwenzekile sakugweba ngokolu hlobo lwethu umantyi ufika jonge kwezanto sizibhalileyo thina xa ucomplaina uza kugweba naye ngokwezi bylaws zenziwe kuthi yeyona nto ndinoyibulela ngoku because iyenzekile kum esizweni. So nakwezinye inkosi ke ifa zikayenze ndicela ziyenze enkosi.
Please take note that this is not a dialogue, but thank you for ratifying that. So that was the first question. Let me take the second question again from this side. Over to you. We are still on this side, on round number 2. On this side. On this side. We'll continue in that fashion. Thank you so much. Let's give him a chance to ask the question.
Thank you. It is based on not knowing that I'm asking. And the question is directed at Mkosi Holomisa with respect to gender justice and gender equality, to give it a different name, or even the presenter on his side. I don't know. I'm learning different things, and I don't know what is the name for the husband of a female chief, Nkosi. Because I know for a male Nkosi, the wife is Nkosikazi. So I want to know just the name of the husband to a female chief. Thank you.
All right, thank you so much. Let's take the last question. Okay, it seems this. Okay, let's take the third question from this side. Mama, over to you.
Enkosi kakhulu. Hayi mntasekhaya. Akusiyo dialogue. Kodwa kuyafuna enzela uba apha mosisithetha ngento ye-customer. So funeke sifundisane okanye sibonisane kwizinto esingazazi ncam. Ukuba bendimamele kakuhle siphuma kwindawo ngendawo ekungenziwa ngokufanayo. Mna ndiphuma emampondweni mbhemu. Uyabona apha emampondweni mntakwethu akonyulwa kwankosi. Asinayo kwalento kuthiwa yidemocracy yokonyulwa inkosi. Inkosi iyazalwa. Ayinguyo lento kuthiwa ngumbundlwana. Umbundlwana ke ngumntana wentsha. Iyazalwa then emva koko ibe inkosi. Silungiselela into yoba singadibanisi izinto ezingadibananga. Ingakhona ke indawo ezonyulwayo, maybe ezindawo zikumtshileyo kunezitrato kubekho i-street committee, then sonyulwe ke sibizwe as ungunkosi. Bendifuna nje mntasekhaya enzela uba ndiqinisekile apha kukho nabantwana abafundayo. Ndilungiselela into yoba kule research bayenzayo ze baedishe bangemki nalo mrhiba wokonyulwa. Hayi asonyuli, siyazalwa. Enkosi.
Okay, let's allow Advocate Katekile Holomisa to comment or answer some of the questions that were posed.
Well, first of all, let me take this opportunity and respond to the question that was asked by Ugama. Are we interpreting customary law correctly? Why do we need to accommodate our customs? I think we do this because there are people who interfere in our affairs, who tell us that we are not doing our things properly. Otherwise, we shouldn't be talking about accommodating our customs. In fact, it should be the other way around, that the Constitution must accommodate itself within our customary law systems. Unkosi uNdlazi undenzele lula apha because she has answered properly on the basis of an informed position about how these matters of money is coming from towers and the question of the election stroke appointment of Inkosana. I don't think I need to add anything more to what she has said. When well, as traditional leaders, you should answer that question yourselves, because indeed I'm not aware. Sorry, please.
It is because anditshatanga. Then I won't get married. If ndiyatshata, that means ndiyabushiya ubukhosi basekhaya ndihambe ndiyotshata. Uyayibona? So awusuba naxhala, Mr. Wayne, that you have to call my husband. You won't see any husband next to me. It'll be me.
Yes, greetings to the House. My name is Mzamo Taimani. I'm from the Center for Leadership Ethics in Africa here at the University of Fort Hare. I just want to raise my voice this day to Ungosi Upatekile Olumisa on the issue of sovereignty of our kingdoms. I think from the presentation that was made yesterday on the issue of the annexation of our kings and being subordinate onto the British Crown under the protectorate of the British Crown, and looking from the resistance to the liberation movements as the continuity of the indigenous people fighting for their autonomy. I just want to pose the question of, during the transition to democracy, where the kingdoms of South Africa that were under the British protectorate were given or declared their full autonomy or their full sovereignty after the dispensation of apartheid, going to the CODESA and all that. So that is one part I'm very much concerned in terms of their autonomy as the traditional leaders, if it was reinstated from the British Crown as they were under the protectorate and they have lost their power during the annexation. Yes, that is just a small point that I want to hear. Thanks.
Thank you once more. The reason why I asked whether we're interpreting our customs correctly, and I'd like to direct this comment or question or whatever it is to Undosi. It's because the example Undosi replied to my question by making when he says his uncle was married customarily and then decided that his wife will not be part of the work labor or labor force rather. Now, you need to firstly find space within our customs which firstly talk of going to a job. So you can't attribute that abuse to our customs because that is not part of our customs. Nowhere in our customs do we ever say this and this can go. The example I made when I said earlier, in Bondoland, pre whatever happened before we called the husbands umyeni, the wife was Nkosikazi. And in turn, the wife would then call her husband Inkosi yami. We do not know where that faded, but that showed the level of equality between these two people. I'd like to drive the point further. A speaker yesterday was highlighting that the ritual of circumcision demands that there is a role played by the mother and the father. That is equality. Now, when we say in this colloquium that our customs are patriarchal, blah, 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 that's what the West taught us. We divide our labor. So then I beg the question again that says, which is more democratic between the customary laws or our customs and traditions versus the Western way? The Western way says, pick someone who will represent you in parliament. Once they are in parliament, they can say whatever in the guise that they are representing you. In the traditional way, an imbizo is called. In Pondoland, again, when the tradition of a firstborn son automatically assuming his father's position as king or nkosi was changed, an imbizo was called, and then they said, there has to be a great wife that will produce an heir, an imbizo. That meant the larger, a vast community should be a part of making that law, a part of making that decision. Now, you go to an imbizo yourself, you 10, you 20, you 30, you 40. Try going to parliament today. The idea of democracy is saying, have a voice. It does not say, take your voice and give it to whoever to represent your voice there. So then I ask this question again, which is more democratic? Customs versus the Western way. Thank you.
Enkosi kakhulu. Cela uphakame. Nondumiso Kisolo, master students upper A40. Now I want to drive your point, Dada, to the topic that you have been assigned to. Your education and customary law. I've been trying to figure out what are the jurisdictions of Inkosi nezikukumkani within the Eastern Cape diaspora. I can see the colonial map, but the post-colonial map is not there. And the reason why I'm raising that is because we have Contralesa, which is headed by Utatu Nonkonyan, if I'm correct. And then we've got a House of Traditional that is headed by Utatu Kwatiso. Now, when are we going now to drive from the houses to create that jurisdiction? Lamhlaba umepwe uba ngowesizwe sobani, ngowesizwe sakwaSicawu, ngowesizwe sakwabanibani, sakwaHolomisa pha eMqanduli, kwaSangoni, kwaTatupetse, kwaTyiso. All those, so that even in the future, asilwi ngesihlalo, because ngoku sikwi 30 years epoch of our democracy, but yet sibona izizwe nezindlu zisilwa. It goes back to court, and the courts zethu is customarily azizude zikwazi ukuhlala sibe namandla xa zinobukhosi obucontestanayo. Now, this is my question. In the post-colonial event of a democracy, I saw Utata Benz Ngamash for the first time being elevated to the position. But when I'm trying to make a research, Tiendi Felishe to place, I'm sure she's going to be here tomorrow. I'm getting the Felishe to place because the voice of the African traditional leaders, okanye the voice of Inkosi, iyafuneka ide ibe namandla so that kuzokulunga nalento kuthiwa yi-moral regeneration, because it's something that is driven by inkosi. Apha Eastern Cape iphelile, because it is driven from the office of the deputy president to the office of the premier. Oscar Mabuyane phike ifike yathi emveni kuthatha uMathanzima yathini yafa. It would have been good and perfect, Mr. Mamumbolambi, Dr. Mbolambi, ukuba binokwenzeka into yoba le conversation ibe yi-conversation that is going to be taken to his students ezi ziyi-500 that uzititshayo eklasini, so that they understand the contextual theoretical frameworks and the perspectives of the African way of life. Because by that uzawukwazi ukuyilimita uyifake eklasini, but not as it comes from straight and interest research to go further study about njengalo mntana uthi interested to pursue i-masters yakhe next year customary law. Because this is very important. Ngoba apha umgangatho nevalue yomuntu omnyama yomXhosa iyehla. I was unfortunate to go to KwaZulu ngeyoxesha kubeka utata ubani kanene Tata Mrs. Zulu. I was not allowed to go to the kraal because there were rituals happening there, but I wanted to find a place panga center that I could take and see. The astonishing thing that I saw Patata was when the rituals were performed in the kraal, there was a spiritual connection. Kwavele kwaphuduma izulu kwamnyama phezu kwesibaya, and ngamadoda odwa. That's what we understand. It's not patriarchy uba amadoda odwa angene esibayeni. The minute kuba khona mhlawumbi ndinethombe legazi ngokweBhayibhile kuzaba khona ingxaki. Uyayibona ne? So ngoku this is the time that we need to understand and take these epistemologies into class, into our kids. Because amabhulu ngokwaye colonizer, xolweni botata. Ngokwaye colonizer, they use our own conscience. They use our own conscience. Colonization started in class. Zange iqale phezulu. Aqale esikolweni kwa unyuka nge-religious studies yenyuka. Umntana omnyama wa colonized from conscious. So thina xa sicima fanele uba sawuhlala kwi-classroom nakwi-office sivalele sititshane and it ends there. When are we going to decolonize? Thank you.
All right, it seems as if all the questions were directed to you, advocate. Over to you.
Oh, beziphendule ezanto zikaPeterson. Oh, another point that was made about the need for traditional leaders to be elected democratically. Unkosi Malahle naye ushilo okubana inkosi are born and selected in accordance with the customs of the people, customs that are informed by the spirits of our ancestors. Udaiman wanted to know if the kingdoms or the sovereignty of the kingdoms was restored. It was never restored. Instead, even the kings were not participating. Unlike in places like Nigeria and Ghana, at the time of the negotiations for independence in those countries, where they were invited, they even went to meetings that were held in England, so that the constitution that would be adopted would be informed also by the views of the rulers of the land and their dependents. That's why we have these meetings. It's because the powers that were taken from us by the colonialists have been inherited by the politicians. You can see that by the fact that indlela ababathanda ngayo abelungu, they undermined the structures that were used by the Bantustan leaders, like as a parliament, and instead rushed to to Cape Town and to union buildings, neglecting the ones that were built for the benefit of the traditional leaders who were forced, like everybody else in the country, to work with the colonial and apartheid governments. Yeah, I agree again with Usigao about what he said, that the abuse of women cannot be ascribed to our customs and cultures. It's all because of what was said by the Dean here, that let us just look at at the rascals, the people who break our laws. People who break so-called common law, they are taken to court and charged, and then if found guilty, punished. So you can't just say because some elements do certain things that are wrong, then you say we must do away with that particular custom because it has been abused. With everything you said, like for instance, there are duties that are performed by the males in the house and others by the females, including between children. And also, Oskazi has her own responsibilities that must not be undermined by even Inkosi yakhe. Of course, again, there's no democracy. People often say juxtapose the system of traditional leadership with democracy. How can the two work together? We are naturally a democratic institution. We don't just wake up as a traditional leader and decide that, no, this is what I'm going to do. I'm going to give those parcels of land to those particular individuals. There are systems in place, checks and balances, that ensure that people have a say in decisions that are going to be affecting their lives. It's just that people don't want, abantu, when they meet, they discuss, debate, argue, but come to a decision which is communicated by the traditional leader. Abantu ke ngobathi, that is the voice of Inkosi, umlomo ongaqambi manga. It is because he articulates the views of the people, having been communicated in that gathering, generally known as Imbizo. So, at Parliament, some people don't even know who their parliamentary representatives are. Abanye basathi ndise Parliament and go because they do not know who their representatives are, because they have no say in the election of their representatives, so-called. All they vote for is Ramaphosa, Zuma, or Mbeki, or Mandela, or the other leaders of the other parties. There's no democracy. Yeah, there's no democracy at this stage where the election of members of parliament is concerned. It's the members of, not even members of a party, especially my party, the ANC, have a say in the election of candidates. They will be given that opportunity, then the list will be taken to the provincial structures, and then they sift people they don't like in the name of gender representativity and minority representation and so on. They have names that appear honorable and so on, and yet, in essence, they manipulate the decision of the people who are members of the party. So, democracy yona iseza ayikabiyo le. Singayibiza nganye igama ke mhlawumbe sithi a new form, because we form new things in South Africa. It's a new form of election of people, but it's not democracy. Democracy is what we practice. What are the jurisdictions of Inkosi in the province and the kings? Well, I would imagine traditional leaders know their areas of jurisdiction. It's easy in the other side of on the other side of the river, because most of the land under traditional leaders was demarcated with boundaries. boundaries that are clear as far back as 1906. So those boundaries remain intact in most cases. So you have an area controlled by a headman in Kosan. Then below the headman you have is bond, as one as bond. Abantu kweliqala kuthiwa sizibonda phaa kuthi zinkosi because they are royalty. Abantwana begazi. They are not elected. The question of election doesn't even arise because kuyaziwa into yobana kuzawungena umuntu akabani asawubhubha ubani njalo njalo. So kuyaziwa ke into yobana i-village ethile has to elect a sub-headman, i-body. That's what we call them, or isbond. Then at a higher level, a conglomeration of these villages headed by isbond or any body constitute that administrative area, which is headed by Nkosan. Then a conglomeration of these administrative areas, especially if they are constituted of traditional leaders who are from the same lineage, constitute the traditional authority area. And then the head of the tribe, the senior most member of these royal families, is designated as the head of that tribal authority. Well, this is a system that was consolidated and modified by Abelungu in order to manage our people. So much that when it was introduced here, it was because the senior leaders, the heads of the tribes around here, were not submitting to the authority of the white government. So they decided to read the system and discover that there are these houses who have senior, what you call children, who exercise authority by virtue of their birth. Then they said those areas must be headed by headmen. But then these headmen, they appointed themselves under the pretext that they were appointed by the communities. If the community decided to elect somebody they didn't like, then that person was discarded and replaced by someone they liked. So that's why they ended up, particularly in this side of the river, not necessarily all of them being of royalty. And then when the Bantustan system was introduced, those are the people that were used, so that they reported directly now to the magistrate instead of reporting to their senior traditional leader of the area. But on that side, they decided that royal family members from these different houses are going to be appointed. Hence, the succession is hereditary in those areas. So the traditional authority areas then in turn, they constitute the area of the kingdom. They are under the rule of the king, who also has in his own seat, he also has a similar system because he has to have his own tribal authority. And then there are headmen there as well over these administrative areas. So the practice is that the prospective heir is put in charge of the administrative area in which the royal seat is located, so that there's a proper system that ensures that there's no unnecessary disruption. But then again, everybody will want to become a traditional leader, even if they know that the rule, the custom, the regulation that was established before dictates that he cannot be. So everybody will want to take a chance to see if he can be fortunate enough to be appointed. So, i-Contralesa and the House of Traditional Leaders, the role ye-Contralesa is to mobilize traditional leaders into one formation so that they can speak in one voice, so that they can achieve what they demand, so that the recognition that we seek happens. So the houses were demanded by Contralesa during the times of the constitution-making processes, so that the houses are informed by the policies that are drawn by Contralesa, which we could call a political arm of the institution of traditional leaders, so that the messages that they take to the house, to the house as traditional leaders and to government, therefore, are messages that are informed by the organization that represents traditional leaders. But then I think this is common knowledge, but the success is registered by the struggles of Contralesa resulted in divisions being created, sometimes and mostly from outside. For instance, when the houses were established, the chairperson, the deputy chairperson, members of the management committee were given some benefits that were denied to other ordinary members. Other ordinary members could only get sitting allowances and traveling allowances. And these houses were not meant to sit as regularly as they should, because they have to monitor the laws that are being promulgated or formulated in parliament. So they didn't want that, the politicians. They then made sure that people will be squabbling among themselves, wanting to be chairpersons and deputy chairpersons and leaders of the house and whips and so on. So you find then that people now tend to forget about what is happening there, because the primary purpose also was that the powers, the empowerment must go to these levels that I mentioned, the village level, the administration area level, the tribal authority level, up to the king, so that people are empowered enough to be able to do what they are supposed to be doing. In the nature of things, Inkosi is supposed to be rooted within his community. He doesn't have to go to Bisho or to Cape Town in order to be able to do his work for his people. But then it became necessary that these structures must be established in the belief that they are going to concentrate on what is required by the people who send them to the houses. This is not a blanket situation that you find. There are, like in Parliament and elsewhere, there are people who continue to be committed to fighting for the rights of the people they represent. And in the case of the houses, that is Contralesa nayo is also fractured. A number of structures are coming up because some people are annoyed by the activities or utterances of some of the people leading the structure. So our enemies, most of whom are the politicians, infiltrate the organization. You find that now people are no longer talking for the members of the organization and the communities they represent, but for themselves in order to be deployed by politicians. You find that come election time, a number of traditional leaders are lured by these political parties because they believe that having them on the list is going to draw more people to come. So it's difficult now for the traditional leaders to speak in one voice because their structures are fractured by all of these things. So I hope inkosi azizundibetha zithi uyile nje wena eParliament kutheni ngokuthetha kanje. Like I said, I didn't quite follow what you were saying by Uchawe, Prince Benz Ngimashe, but he is in Parliament. And he is in Parliament because he is a member of the ANC, like I was in Parliament for those many years on account of my being a member of the ANC, not because I was a traditional leader. If I was not a member, even if I was a traditional leader leading the organization, I would not have qualified to be selected to go to Parliament because I don't belong to any branch of the ANC. So I'm not sure if it's elevation or what to be sent to Parliament, but it's a good position to be in because you're able to do all sorts of things, including expressing your views to the powers that be. Moral regeneration movement has collapsed. Yeah, you see, the other problem is that either by ourselves or because of the decisions of the politicians, we tend to outsource our lives to politicians. Everything must be endorsed by politicians. And yet that is not how things are supposed to be done. We're supposed to be moving about, having meetings of this nature without being guided by politicians. Because politicians at the end of the day will want to ensure that the outcomes of this meeting are going to benefit the parties to which they belong. So that come election time, you remember them and then you vote for them accordingly because they were with you. So South Africa is failing in taking up its own lives into their own hands. There are so many things that we should be doing ourselves without even looking at politicians. Politicians, nemisebenzi yayo that they are supposed to be performing, but it doesn't mean they must run our lives. We used to decolonize the notion of what? So, oh yeah. Yeah, you are right. This question of patriarchy. I think we need to unpack it also, because we'll end up delegitimizing certain terms that in themselves are not bad. As I said, patriarchy comes from the term pater or something, father, just as there's matriarchy, umama, umzali. But because mhlawumbe ke abanye abazali basebenza kakubi le position bakuyo, ending up doing bad things, instead of protecting and promoting and supporting and growing the family in a good way, they just abuse the powers that they have. Then, as the professor, the dean said, you must look at the scoundrel and not at the system, and try to destroy it just because there are people who are abusing the system. The conversation should be taken to the students, to all corners of society. We should be talking about this. Umadiba Apa said, when opening the House of Traditional Leaders, or when he was at my place when I was installed, that Inkosi had been complaining for all along, saying that their matters are not being attended to. But Abahlekazi need to understand that we needed, as the ANC, to consolidate the structures of governance, take away the power from the former oppressors, and put up systems that they also understand, so that they are not scared away. Now the time will come, he said, after the establishment of these houses, for you to come up with solutions to the problems. Sorry. So that, because if ku promote amasiko nesithethe zabantu abamnyama, ku promote inkosi, bazokoyika belungu because bamoshile bathathe umhlaba wokhokho bethu, bathatha amasiko ethu, basinika amagama abo, becinezela wethu amagama, ukwenza into bana even spiritually sizibone si-inadequate uba ngaba asinasilungu. If you are not able to speak English, we feel inadequate. And there was a time here when this area was called Little England. And we were proud about the fact that, yes, we were black Englishmen and so on. And then when someone has been baptized, a letter is sent to England. A letter is written that 2 or 4 converts, 4 kephas have been converted, So we need so many pairs of trousers, so many shirts and so on. Inkosi, ndiyabhyuza le mbeko ingaka ndiyiphuka yonke. Thank you.
All right, thank you so much to our panelists for presenting very interesting topics. And this is based on the questions that were posed by some members of the audience. Let's give them a round of applause. You are excused. All right, we've officially come to an end of our session. I would like to call Dr. Ndlovu, the head of Department for Public and Constitutional Law, to come forward so that he can give us a way forward. Where to from here? Dr. Ndlovu? Dr. Ndlovu? Okay. This is what I'm going to do. I'm going to stand in for him. All right. Now the time is 20 to 5. Yes, it is 20 to 5. And this was the last session of the day. This is what we are going to do. We have a gala dinner right then. We have a gala dinner that will be taking place at 1800 at 6 o'clock. We're at Skurent Center down the road. So that is where we're going to meet, from here to Skurent Center. On that note, thank you so much, colleagues. Bye, everyone.